Ladies and gentlemen, dear colleagues, it is a great pleasure to welcome you at our conference on competition law and digital transformation here at Paz Mány Péter Catholic University Faculty of Law and Political Sciences. We are co-hosting this event with University Atmajaya Yogyakarta of Indonesia, our Catholic partner university. Pope Benedict XVI wrote in Caritas in Veritate, "In a climate of mutual trust, the market is an economic institution that permits encounter between persons, inasmuch as they are economic subjects who make use of contracts to regulate their relations as they exchange goods and services of equivalent value between them in order to satisfy their needs and desires." Yet the restriction of the market and the promotion of competition policy are not far removed from Catholic social teaching either. As Tihomir Tóth, former president of the Hungarian Competition Council, professor of Paz Mány law, and current judge of the Court of Justice of the European Union, once noted, the Vatican teachings help us remember that business and morality do not belong to two different worlds, and that markets should serve the entirety of mankind. While encyclical letters acknowledge the positive role of free markets, the exercise of economic freedom being an important part of human dignity, they warn that competition can be preserved only if it is curbed both by moral and statutory rules. End of quote. Indeed, just 30 years ago, at the time of the re-establishment of Paz Mány University and the Faculty of Law in particular, it was the founders' express will to introduce competition law as a separate course in its own right into the faculty's curriculum. Almost 30 years ago, when I started my studies in this very building, faced for the very first time with the exciting subject of competition law, the regulation of markets, and antitrust enforcement, digitalization seemed like utopia. Little did we suspect that just one generation on, we would be sitting here in the ceremonial hall named after John Paul II, with some of our presenters and audience following us and participating online, discussing regulation of digital markets, consumer protection in the digital age, data protection, and merger control issues in digital markets. To be in step with the times, I asked ChatGPT which role antitrust enforcement is to play in digital markets. This is what ChatGPT answered. Antitrust enforcement plays a crucial role in emerging digital markets to promote fair competition, protect consumer welfare, and ensure market efficiency. The role of antitrust enforcement in emerging digital markets can be summarized in the following key aspects: preventing monopolistic behavior, promoting competition and innovation, addressing data and privacy concerns, examining mergers and acquisitions, and international cooperation to align enforcement actions. Thus, I think we managed to create a conference program that actually complies with what ChatGPT also suggests. So while ChatGPT may be taking away our job, it is still my role as Vice Dean for International Affairs of Paz Mány Law to wholeheartedly welcome you all to our conference, to thank the presenters for their participation, the audience for their attention, and to wish everyone a thought-provoking, fruitful conference. Thank you for your attention.
Good morning, ladies and gentlemen. Dear Dean, Faculty of Law and Political Science, Paz Mány Péter Catholic University, Professor Lankos. Thank you for holding conference, the conference which we jointly bring into life. Speakers and participants of seminar, welcome to the conference and thank you sharing your work to the conference. Member of Faculty of Law and Political Science, Pasmani Peter Catholic University, all of you participants, lots to thank to all of you that we can hold this important conference. We, Faculty of Law, Universitas Atmajaya Yogyakarta, work hard together with the Faculty of Law and Political Science, Pasmani Peter Catholic University, to mobilize important works on competition law and digital transformation. We ourselves, as a faculty, contribute in working on research ourselves on the subject, sharing work with Indonesian jurists and academia in the field of competition law, holding our national seminar in 29 of March 2023. Arriving in Budapest in person, I do myself find opportunity to listen and to share with speakers and participants. I would also submit to this conference, as I value your contribution of thought, that I want to submit my work myself as titled Contemporary Antitrust in Indonesia Law. I would later to give my paper. I hope this will be accepted. Now, allow me to give our highest appreciation to our Dean, as you represent our joint conference, the Wayang Kulit Puppet. Shadow puppet in Indonesia, especially in the Javanese communities, wayang represent the value and the image of good and bad. They are like a mirror, and in the absence of positive law, wayang kulit serve as possibilities of doing good. Now, let me bring this wayang kulit to you. Yeah, this is Sri Kandi, a hero from the bad and good things.
Thank you.
Yeah.
It's wonderful. Thank you.
Yeah, thank you. Thank you very much.
I have it. So I prepared an hour-long welcoming speech, but no, I didn't. Ladies and gentlemen, welcome everyone. We are really happy to have this two-day-long conference. We have over 120 participants, many online, some offline. We can already see that humans cannot be substituted by AI and machines and all the other available tools you can use to gather knowledge. We will discuss many very interesting topics. I don't want to take away the job of the speakers. I even let ChatGPT wrote my welcoming speech, regenerated them a few times, and then decided, well, these are topics which I could actually read out loud as a welcoming and introductory speech. But I decided not to, of course, because we also see the failures of such language models, generative language models. They can repeat knowledge, but for them it's much more difficult to come up with new ideas, with intuitive ideas and stuff like that. So we will discuss all these issues. I'm really happy that we have so many speakers, so many participants from Asia, from Africa, from the United States, and also, of course, from Europe. And big thanks to András Pünkösdi, who was the heart of organizing this conference. He put a lot of work into this, so thank you so much. And let's have a nice day today. Thank you.
Good morning, and happy to meet you all finally. I, with András, work as a co-editor for this conference and further publications of article. I have to thank you all, and also thank you for the Dean and the Dean's team for holding this conference. As I understand, we as Faculty of Law at Atmajaya Yogyakarta University ourselves develop a study before we come to this conference. As far as we can do, we finally can come up with two key topics that we can share with you. One is the role of governments of the state, and the other one is how to define risk. On the first one, as we holding the conference, we still at the level of discussing how the state can manage competition, but in a way did not create another moral hazard. So this is the idea. And the second one is on the risk. As we understand, with the coming of the whole data in Indonesia and lots of e-commerce coming to everyday life, we're still in the level of how to manage to assess the risk. So we come up with these two topics as we also having our own presenters. So I forgot to say my name. My name is Henry Thomas Simarmata. I serve as advisor to Faculty of Law at Atmajaya Yogyakarta University. I thank you.
So we will start with the first panel then. Thank you so much for the introductions. Szerintem azt érzem. Diákon betöltő. Diákon betöltő. Sophie nem jött. Online lesz. Okay. Yeah. So, we are just like Toyota, just in time. Okay, so I'm really honored to have this excellent panel with me. From the European Commission, we will have an online presentation. This is also one of the advantages of these technological development. Actually, it's not a development, it's just our habit changed. So we got used to having online conferences or hybrid conferences. Our first speaker will be the president of the Hungarian Competition Council, András Tóth, who unfortunately has to leave after the presentation. We are already thinking about fining him for refusal to supply, but of course we will deliberate whether there is an essential facility there or not, and depending on that we will take our stance on that. So please.
Probably next time we can avoid this situation if we just send the ChatGPT generated text and presentation to the conference. In that case, we can avoid this situation, I think. So, thank you for inviting me. It's always a pleasure for me to be here in my alma mater, actually. I've been asked to talk about today market anomalies in the digital markets that care for regulation. And I would like to start that I would like to focus on the online platforms because I believe that this is the digital technology which actually generates the most serious market problems in the world. The online platforms created an unprecedented online media power in the human being's history. If we look at the number of active users of Facebook, it actually reached 2.9 billion monthly active users in the world. This number is higher than the combined population of India and China, and Google has a higher revenue than the Hungarian GDP from last year. That's a totally new situation in the human being history, that we have such big entities, online platforms, who are mainly media companies in the online domain. I know that I have to focus on the market anomalies, but I would like to mention that we have many other anomalies as well in connection with the online platforms. So not the market-related issues are the most important, and not the single problems with online platforms. I just listed a few of them: election, disinformation, European culture, journalism, the traditional journalism. It's a rarely discussed topic, but I think it's important. And national security or sovereignty issues. It's a well-known data that more than 90% of the European data actually transferred to US companies who have, due to them, the US intelligence agencies have a direct access to this data. Not to me who are saying that, but the European Court of Justice in its landmark decision in the Schrems II emphasized this fact when decided to suspend the Commission's framework decision under the GDPR safe harbor agreement between the EU and the US. But I've been asked to focus on the market problems generated by the online platforms, and I just listed a few of them. Each of them is very serious from European perspective. So if we look at the cloud, 80% of the European data stored in the clouds managed by the 5 large US companies. No one in a European cloud company who could compete with them. So I mean Google, Amazon, and Microsoft, the top 3. Google search dominates 90% of the online search market in the EU. Mobile operation system in the EU dominated by Google. Social media in the EU dominated by Facebook. And artificial intelligence, very, very bad news. So if the artificial intelligence is the technology of the future, or the current situation as well, the European Union is lagging behind EU, US and China. So without data, we cannot make reliable artificial intelligence. If the US companies, based on the zero price business model, actually acquire almost the entire databases and the personal data truth of the European Union, we are not in the situation to build a reliable European artificial intelligence. Each of them a serious problem, and the competition law is not the tool which is well prepared to address those problems. Okay, so not only the market-related issues are important in connection with the digital economy. This is my first important message, and the second, that the competition law is not the most important player in the field. And what the competition law did? Not too much. What did? It was controversial and insufficient. It was controversial, and I have to highlight here the famous German Facebook case. which a very good example of the controversial competition law enforcement in this field. I can highlight also the merger decision, but I would like to talk about the mergers a little bit later on. So the German Facebook case has two phases. So firstly, that's a very innovative competition law enforcement, and that's very German. So it is not unique in Germany, but on European side, that's very strange, but not in Germany, that if the infringement of a specific law can be due to the dominant position, that can be an abuse of dominant position. That's very German, and it is not an accident that the Bundeskartellamt applied the German competition law in this case and not the European competition law in this case. If you remember, the Bundeskartellamt said that in cooperation with the German Data Protection Authority, that when Facebook accessed to the users' data outside sources of the Facebook without consent, the Facebook violated the GDPR. That was the opinion delivered by the German DPA, and Bundeskartellamt said that this violation of the GDPR due to the market position of Facebook. So this is the engine behind of this competition law case. But the message of this case is that, and this is the dark side of this decision, that the gatekeepers, competitors may be prevented from accessing data through gatekeepers who can refer to GDPR as a shield against the competition. And actually, it happens. Okay, so the UK Google Sandbox case is about that. So after this decision, Google decided, we know that Apple already implemented the same policy in its ecosystem, but Google announced that the Google will protect its users' personal data. It's very strange. But actually they decided to exclude the third-party cookie from the Google ecosystem. And the Google referred to the GDPR, that without any consent, I cannot allow you to have access to my users without the consent of my users. And Google announced the exclusion of the third-party cookies from its ecosystem, which means that the Google's competitors in the online advertisement market can access to the Google data only through Google. The third-party cookies allowed the Google's competitors to circumvent Google in the past, but after this decision, as in case of Apple ecosystem, the Google will be the only player in the Google ecosystem through which the Google's competitors on the online advertisement market can access to the Google data. That's a new phenomenon, and the UK Competition Authority initiated a competition procedure against Google, which ended up with a remedy end of last year. According to this remedy, the Google committed to gradually excluding third-party cookies and providing competitors with an alternative access option. Everyone is curious about this alternative option. Okay, so no one knows about that. What does it mean? My opinion is that the data sharing request coming from Google's online advertisement competitors cannot be rejected in the future because of two reasons. Those data are mainly big data, which means that those are not personal data because it is an unstructured data truth. But even if it is personal data, I think that Article 6C of the GDPR, which is the performance of legal obligation, could be a good legal basis to get the Google's competitors access to Google users' data without consent of Google users. I know that it is about the competition of toxic products, but it is not a new phenomenon in the competition law. We used to protect competition in toxic markets as well, like alcoholic beverages, or I don't know. So it is not the problem of competition law, but this issue highlights that we don't have a legislation, neither European level nor national level, which targets or which gives the possibility to evaluate and assess the value of the innovation. That's a problem. My opinion is that not all types of innovation valuable. That's important. Not all types of innovation valuable. Everyone can decide the value of the innovation what we are using. I think there are differences between innovation and innovation. If the innovation gives me something added value, that's useful for me. But if an innovation just takes away something for me without giving benefits or just harmful for the society, like in case of the fake news, elections, impacts, so on, so you can decide. So, but we are not the situation because we don't have power to decide about the value of the innovations. I think, for example, the merger control in the EU competition law or the national competition law has some chance to do that. So, how to value the future how to value in connection with the mergers the impact on the privacy, for example, or the quality of our life. The merger control can be enhanced in this regard. Another issue with the competition law that we had many competition law decisions in the past few years. If you combine these fines imposed by the European Commission, you probably realize that Google gets almost 8 billion euros fine. That's nothing. Okay, so 8 billion euros. Last year, Google generated 324 something like this billion euros revenue. So 8 billion euros. It is just I don't know 5%. I don't know. So it's a very much. Yesterday I participated in a conference and we addressed the NIBIS in NIDEM, and I said that please do not overestimate the role of the NIBIS in NIDEM. Okay, so the DMA, for example, decided to increase by 20% of the previous year's net revenue, the fine to be imposed. It is not an accident. So I don't see that the competition law is in the position to effectively deter these giants. So the NIBIS in NIDEM issue, I cannot imagine that can be an issue. According to the European Court of Justice, the final fines should correspond to the seriousness of the infringement. There is no fundamental right which cannot be infringed. If we can be compliant with the proportionality requirements. I think in case of the fines, in terms of the big tech, we are far from imposing proportional fines. This is the evidence. Okay, so the competition law is unable to deter. That was the reason why the European Union decided to complement competition law and therefore adopted the Digital Market Act, which not substantive way but procedural way departures from the competition law, because the remedies and the do's and don'ts regulated by the DMAs coming from the competition law cases. So it is just a procedural complementary regulatory step which accelerate the procedure and the remedies against the big tech. My final point is the question of my presentation, which was given to me. What additional regulatory steps are needed to address market problems? And just focusing on market problems. As I already mentioned, we have DMA. and the preservation of innovation innovation competition is key in this market. The DMA addresses this issue when actually opens the platform's ecosystems and ensures the contestability and fairness. There will be a presentation about the DMA, therefore I would like to talk about this issue too much. What I already mentioned, that I see some potential in the merger control. The European Commission ordered an impact assessment in connection with the DMA, which highlights that the firms facing larger competitors innovate more than monopolies. That's an interesting highlight from this impact assessment. This is the reason why the big tech buying competitors and potential innovators. They are already read Schumpeter as well, so actually it is clear for them that the potential threat is coming from the ideas and other innovations. So this is the reason why they want to buy. My question is why we have to allow this type of growing. So if they are the biggest companies ever in the world, why we have to allow them to be bigger through mergers? So I cannot accept that we allow those mergers for the 15 years without any consideration. So the last example is the Google Fitbit merger. The European Data Protection Board intervened in this issue, in this merger. The Commission prohibited Google from using the Fitbit data. But my question is, what makes sense in this case then? So if the Google cannot use the Fitbit generated data, what is the business reasons behind this merger? So I think the outcome could have been the block as well. So I don't understand why we have to assist to allow growing the big tech if they have enough money to innovate. I think this quotation from the DMA impact assessment is the answer. So I see some space to further enhance the merger control, and the merger control is a key from preserving the innovation. But to do that, we have to be in the position to be able to value the impact of the proposed merger on the quality of their life. This is not the situation at this moment in the EU. And there are two territories which absolutely outside of the competition law. This is not related, but relevant from the market anomalies point of view. The first is the data exploitation, which is coming from the privacy paradox and the asymmetrical information situation between the platforms and the users. This is a strategic issue. So all data exploited because the zero price business model companies actually almost all of European data transferred to the US. This is a strategic issue. So without data, we won't be able to build a reliable artificial intelligence. So if the US companies owns the European data, it means that European data strengthens US strategic advance in the future, which will be about the technology. That's a bad news. So what we can do with data exploitation, which is a market problem, the competition law, nothing. The DMA increases the cost of end-user profiling because the DMA actually accept only the consent as a legal basis. So actually exclude any other legal basis of the GDPR and only accepts the consent. So if the big tech wants to continue the targeted advertising and the profiling, the consent will be the only legal basis. That's a step made by the DMA. The DSA, the Digital Services Act, goes further when prohibits the profiling and the targeted advertisement if the targeted recipient of a minor. And the Digital Market Act, I think, has a very, very good theory about how to treat the data exploitation, but very strange that how the EU brave when we have to regulate non-personal data, because the the Data Act prohibits gatekeepers to get access to the data generated by the IoT. That's a good news. So this is the first very brave step on behalf of the EU. So actually, in case of the non-personal data, the Data Act prohibits big tech using non-personal data generated by the IoT. So my question is, why we are not so brave in connection with the personal data? In connection with the data exploitation, we see some regulatory steps outside competition law. And the new category of media intermediaries, I started with this and I would like to finish with this. So this is an unprecedented new phenomenon in the human history, that we have media companies having almost 3 billion users. It's huge. It's a never seen sight. And this is the media company which is not targeted by the media law. This is a problem. So I think that this is the future of the media law. So we put aside the media law in the past 20 years, but I think it is the time to reconvene and let's try to deal with the media law. This is the solution for the problem of the online platforms who dominate now the online publicity. We have to regulate the election-related impacts of the online media, which actually regulated by the offline media law. We have to regulate the advertisement issues, how frequent I can get an advertisement. If you know, the media law regulates it, so it is regulated that within 1 hour how much advertisement is allowed to be displayed in the television, for example. It is unregulated in the online territory. And finally, the new category of media intermediaries also tempts that we have to create something which gives the possibility to users to decide if they would like to use the online media services for money, for cash, or for personal data. At this time, we don't have this decision situation. If I am a privacy-sensitive user, I don't have the chance to choose between the privacy-sensitive option of subscription or registration. My only option is take it or leave it. So at the end, just shortly summarize my presentation. So the market problems caused by online platforms are the most serious in the digital economy. And not only market problems exist, competition law deemed to be insufficient, merger control must be strengthened, and regulatory treatment of data exploitation and new media intermediates needed and exceeds of competition law. Thank you for your attention.
Thank you very much. I'd like to have some technical help with our online presenter. Okay, now we will have the opportunity to welcome Sophie from DG Comp, for which I am very happy that we have a speaker from DG Comp, because you know this is a joint task force basically, and as a competition lawyer, it's very interesting to see how competition lawyers see the DMA, how they can reconcile DMA with their century-old habits. So, okay, so I just started watching Super Pumped about Uber, the company Uber. I think it's on Netflix or Sky Showtime. There is the keyword frictionless. We are not yet frictionless here, but but probably that will also improve in a few years. Okay. Okay, Sophie, can you hear us? Because we can't hear you. Could you turn on your microphone, please?
Hi, can you hear me? Hello?
Yes, now we hear you.
Okay, great. Great, thanks, and thanks for providing me the opportunity to join from Brussels today. I would like to introduce you to the DMA, give you a bit of an overview of the legislation, the objectives, its architecture, and what it is designed to solve, and then also address a little bit some challenges and the timeline ahead of us. So I'm working in Directorate J in DG Competition, in charge of implementing the DMA at the moment. So next slide, please. So as the previous speaker already alluded to, there has been a worldwide reflection process on the market power of digital market participants, which has relied on, or it was based on, the increasing importance of digital service in all our daily lives, and the characteristics of those services, which are driven by extreme network effects, scale economies, and a resulting almost absolute market power that really allows a conduct which is unfair and stifles innovation and competition in those markets. So the problems that were identified were that gatekeepers of these digital market services were really unfair, and there was weak contestability of those markets as a result, so very limited competition and innovation. In addition, because this is the EU, there was also a bit the risk of regulatory fragmentation, because some countries had started legislative processes in this area. So there was a need to create a European instrument to address these challenges at a European level, since these services are obviously provided across borders. So the DMA really addresses the market failures that were identified so far. And as my previous speaker already said, so the problems identified really came to light also through the many antitrust cases that DG Competition, but also national competition authorities ran in the last couple of years. And those cases have really had an impact, and that's very visible, I think, in the DMA. In the different provisions, you can almost read through the obligations and say, oh, this is for Amazon, and this is for Google. So it really shows that these problems are very real and have found their way into a regulatory instrument that is designed to address the unfair conduct of gatekeepers. Next slide, please. So I'm not going to go into the detail of the DMA versus competition law, because the previous speaker already touched on that. But just to say that indeed, the DMA is not there to replace competition law in the form of antitrust rules and merger control, but rather complement it with an ex-ante regulation that defines certain do's and don'ts for very powerful companies So it is quite limited in that sense to those companies that have market power, and also to a limited set of services. So there is a place definitely still for antitrust rules to apply to all the companies that are not captured and all the services that are not captured by the DMA. On the other hand, hopefully the DMA will, at least in this area of digital markets, take away some pressure for the colleagues investigating unfair conduct, because it will hopefully lead to some problems to be addressed upfront rather than having to go through lengthy procedures to correct conduct and enable undistorted competition in those markets. Next slide, please. So the legislation, the DMA, defines 10 core platform services to which it applies. And the criteria that were considered to define that list was really to look for markets that are highly concentrated, where there's only a few large players, where really the markets are not contestable at all, and where the unfair conduct has a direct impact on business users and end users in those markets. The list of those services initially was numbered only 8 services, but through the legislative process, 2 more were added, which were virtual assistants and cloud computing services. So the list is now comprised of 10 services, and we're currently in the process of considering how are these services actually delineated? Where are the borders? Because, as you might be aware, many of these services overlap to a certain extent. For example, an online search engine shows also results of online intermediation services, which are, for example, services like Google Shopping or marketplaces. So there is an overlap there between those services, and it's important for us to get these boundaries right. So that's what we're currently trying to address here at the Commission ahead of the designation processes that will start soon, which I will get to later. Next slide, please. So when is someone a gatekeeper? The legislation defines this alongside 3 criteria. So first, the gatekeeper has to have a significant impact on the internal market. Secondly, it needs to operate a core platform service, which serves as an important gateway for business users to reach end users. And third, it needs to enjoy an entrenched and durable position. And while this is obviously a qualitative way of expressing things, the DMA includes some presumptive thresholds. So this means if those thresholds are met, the presumption is that this company with those services is a gatekeeper for those services. So for the first criterion, significant impact, this is related to the turnover of the company in the EU or to its market capitalization. If the company exceeds certain thresholds as established in the legislation, then the presumption is that it has a significant impact on the internal market. The second criterion, operating a core platform service, which is an important gateway. This is tested with user thresholds, so active end users and active business users who need to exceed certain numbers. And again, if a company with their services is above those numbers, the presumption is that they are a gatekeeper for those services. Finally, the last criterion, to be have an entrenched and durable position. This is being met if the user numbers are exceeded for the last 3 financial years. Now, gatekeepers can rebut this presumption, but the criteria for rebutting are very, very narrow. And this is really only an exceptional measure so that we do not have any false positives, basically we're not trying to capture companies who ultimately are actually not an important gateway, for example, for business users to reach end users. So this is really an exceptional opportunity for companies to rebut and will be used very and interpreted very narrowly. Next slide, please. So to give you an overview of the obligations and prohibitions, I won't go into all the detail, but so there's data-related provisions which have the aim of ensuring ensuring that data is available to business users just as it is to gatekeepers. I'll go into the data-related provisions a bit more in detail. Then there is commercial relations-related provisions, which really aim to address the ability of gatekeepers to set terms and conditions at their will, without there being any ability for business users to negotiate, really. So basically reflecting the market power that gatekeepers have, and addressing that issue of being able to impose certain terms and conditions. The obligations related to mobile ecosystems try to address the issue that gatekeepers often have sole control over, for example, pop-up messages or certain abilities to switch or add services to their service. So this is their ultimate control, and the DMA affords some ways for business users to address issues with that. Then there is fair access rules, ensuring that gatekeepers cannot preference their own services on their core platform services, for example, when they are vertically integrated. And ensuring there is fair and reasonable conditions for access to those core platform services. Then in relation to online advertising services, there is a real issue with respect to the transparency of fees and remuneration in that area, and pricing. So there's a number of provisions ensuring that advertisers and publishers have access to the relevant data to be able to verify performance and pricing, and then basically make their choice with which provider to go. Finally, there are some interoperability provisions and some rather limited tying provisions. So the tying provisions do not actually reflect proper technical or contractual tying, but they are more softer and related to digital markets specifically. The real tying or actual proper hard tying conduct would still be addressed by antitrust rules. Then there's also, obviously, to ensure enforcement, a number of reporting obligations for gatekeepers. Next slide, please. So to give you a bit more of a sneak peek into one area of the obligations, I chose the data-related obligations. So the first one is a ban on data combination. So this means that a gatekeeper cannot process personal data from third parties for the purpose of online advertising or combine and super profile users. So this is meant to address contestability first and foremost in online advertising services, but also other digital services, where the creation of super profiles of users really gives a competitive advantage to gatekeepers. Then there is the data silo obligation. So this means that gatekeepers cannot use non-publicly available data to their own advantage and to the disadvantage of their competitors. This is basically one of the obligations which has the name Amazon attached to it, as you can imagine, because this is a conduct that was also just subject to an antitrust case, which came to an end with commitments of Amazon. Then there's data portability obligations, which are designed to ensure the ability to switch or to multi-home for end users, which would also increase contestability of digital services. Next slide, please. And then there is access to data generated by users. So gatekeepers must provide business users with the data generated by their end users, so that they can actually innovate and improve their services and allow them to be competitive. Because as we know, data is the new oil. So without data, those services are unable to compete properly. Finally, another data-related provision is meant to address the contestability issues in online search engine markets. So it's meant to give access to existing online search engines to be able to train their algorithms based on click and query data of gatekeeping online search engines. And you know who I mean with that, I guess. Next slide, please. So the enforcement powers we have as the European Commission are inspired by antitrust powers and merger powers, to be honest. So those are requests for information. We can at any time address requests for information to gatekeepers or third parties to investigate conduct. We can take statements, do inspections, impose interim measures, and make commitments binding. Could you click again, please? Yes, but these enforcement powers have a slight twist, which is obviously due to the digital nature of the services. So we can also ask for access to data and algorithms. And then I think one improvement is also that there is a clear obligation in the law requiring companies to have a compliance function with sufficient authority and resources. So this will be, I think, an important step towards a regulatory dialogue with the Commission on the implementation of obligations to have a proper interlocutor on the other side. And finally, there is some retention obligations for data in relation to monitoring of compliance. Thanks. So in terms of timeline, the legislation came into force on 1st November 2022. It's been applicable since last week, 2nd of May. And on the 3rd of July is the deadline for notification for those gatekeepers who exceed the thresholds that I talked about earlier. So by the 3rd of July, gatekeepers need to notify their core platform services to us. And then the Commission has 45 days to assess whether to quantitatively designate those gatekeepers for their services. And then from the date of designation, the gatekeepers have 6 months to comply with the obligations in the DMA. So you can imagine 6 months is not an awful lot of time. So the process is well underway for many gatekeepers who are engaging with us already on how to implement certain obligations, because there is a lot of IT development behind some of those. Then in late 2023 and beyond, we will at some point start market investigations into rebuttals that we will receive, also into qualitative designation for some gatekeepers, because some services may not be covered in the first round of quantitative designations. And then we will obviously start investigating also if there is any non-compliance with obligations, and engage in specification requests. These are requests from gatekeepers who can ask us to work with them to implement certain obligations which are rather high level in the DMA and which will require further specification. And then we will start becoming a supervisory authority as well, and ensure monitoring of the obligations. Okay, thanks, and happy to answer any questions later.
Thank you so much. In principle, we have the possibility to ask questions on YouTube or here personally at the end of the session. So if you have any questions, then please take note and keep them until we get to the Q&A. So our next speaker will be Judith Firnix, who is PhD student of mine, but more importantly, She has extensive experience with competition law, both from business and regulatory side, and she is also a valued member of our research center, so we have basically all three important limbs present: academic, practical, and regulatory in one person.
Thank you very much for the help, András, and thank you very much for the introduction, Pál. Well, actually, with my age, it's very important to understand, thank you very much, that we cannot give up the pace with which the digital markets are developing. And my attempt in the field of the PhD studies is to keep this pace. And I'd like to represent an aspect of businesses, because businesses see the regulatory changes through the lens of compliance. Well, digital compliance can be defined in a broad sense as a complex set of internal preventive measures performed by firms to adapt to the changing and the fast-changing economic and regulatory landscape. Digital transformation requires adaptation, both on the supply side and on the demand side of the markets. On the supply side, for traders and platform service providers, adaptation means that new legal obligations have to be translated to the language of internal rules and requirements. On the demand side, the focus is on the empowerment of consumers, of e-consumers, we can say, which means how can the adoption of new skill sets be supported in order to enable consumers to find their path in the world of fast-changing digital transactions. The rapid and continuous evolution of technological markets has been transforming the environment where firms compete and consumers take their decisions. Digital transformation is not anymore a technology strategy. It has developed to an overarching business strategy which is fully reshaping value chains, creating new value chains, and reshaping the very nature of business-to-business and business-to-consumer transactions. The push to maintain and even increase a competitive advantage drives increased investment in new technologies. Oh, sorry for my voice. In the age when, among others, we could witness the impact of disruptive technology developments, businesses need to invest more time in reassessing and managing risks coming from existing technologies, which shall remain, whilst at the same time, the changing context, they need to ensure that an additional effort is put into managing risk arising from new technologies. Hence, it's important also from an academic side, I think, to gain a better understanding how levels of industry preparedness grow, and as we can see, according to a recent survey, an optimistic approach can be identified, how technology risks are appreciated and mitigated, and last but not least, what plans businesses adopt to manage present and future regulatory risks at a time of significant change. As we can see from the results of the recent survey, the overwhelming majority of the firms has a strong confidence that their legal team's effectiveness in terms of identification can mitigate the risks related to current technologies. The initial steps of risk management are the identification and evaluation of risks. The criteria to be applied in this process are very diverse, even in traditional markets. There are geographical location and cultural embeddedness of the businesses, sectoral expectations, market structure, regulatory environment, range of consumers, and also business partners, which have to be taken into account. Digital economies trigger economic relations which are often difficult for the market players to navigate in, and which can be represented in dichotomies training the regulatory framework. If we examine one direction on our regulatory compass, which represents these dichotomies, we must never forget that other directions are always simultaneously relevant. The pervasive character refers to the presence of digital technology in society. We all benefit from digital applications. They are ubiquitous. We use them for studying, working, planning our leisure activities. We recollect health information. And there are the social networks and chat services, which are already prevailing, the channels that people use for informal communication, at least. But at the same time, monetization of social relations and the adoption of AI as a technology are such issues which are associated with deep ethical dilemmas, to which the formulation of the right answer remains to be found still. Therefore, despite widespread acceptance, digital technologies are looked at with suspicion. We may feel that we cannot live without them, but at the same time, we are not fully convinced or even aware of the full set of consequences of their use. As András Tóth already mentioned, regulation is not only about market issues. Therefore, for policymakers, this has the consequence that regulatory responses address more than just technical and economic problems. They also have profound implications for the underlying value structure of society. Understanding and interpreting the scope and subject of existing and proposed pieces of regulation is very difficult because digital markets tend to develop very quickly. They appear in an overnight, spread over a short time of the period of time, and they bring about significant changes in production and also in consumption processes. New business models can quickly reshape markets, create new markets, reallocating the distribution of profits between different actors in the value chain. Therefore, a significant feature of digital markets is dynamic change. At the same time, digital economy is defined by connectivity and telecommunication and computing infrastructure. Communications and IT infrastructure, however, can only be set up through a significant long-term investment. And these long-term investments require stability and a certain level of transparency of future economic developments. Today, this tension between dynamism and the need for stability is one of the main concerns of policymakers. The tensions in the value chain cannot be avoided by the policymakers. Decisions are made more complex by the fact that the dynamic environment, even in the time frame of a normal legislative process, can make a new regulation obsolete even by the time it enters into force. Geographical fluidity of digital markets entails a further dichotomy. Digital technologies allow economic transactions to be carried out from anywhere in the world. Thanks to the internet, physical presence is no longer a relevant issue if we speak about work, production, consumption or communication. However, geographical fluidity also means that digital markets are very sensitive to regulatory fragmentation. For digital businesses, it is typically important to take advantage of the network effects, which increase with growth, so the chances of success can seriously be hampered by multiple regulatory frameworks in which different geographic regions and countries have different requirements. Finally, The fourth dichotomy represents the economic particularities of digital markets. On the one hand, digital goods and services owe their success to their immediacy and simplicity. We can easily use them. They are operating in an intuitive way. On the other hand, the underlying economic dynamics of these simply usable services are usually very complex. Multi-sided markets connect very different groups of actors, such as consumers, business users, content producers, infrastructure owners, and virtual operators. The boundaries of traditional roles are blurring. Just let us think of the prosumer role of the consumers, when by the consumption they are also participating in the production. Let us think on the video sharing platforms. And there's a new phenomenon, as already mentioned by the previous presenters. Platforms play a complex technological, economic, and social coordination role. But I can see the smiles on some of the participants who have already met some previous variants of this slide. Not surprisingly, because I use the underlying map of digital regulatory universe for different purposes. Well, the map includes those relatively recent or proposed pieces of EU legislation which are supposed to be directly relevant to any market player being present in the digital economy, which means these are the cornerstones for risk identification. To represent the regulatory paradigm shift which we are facing nowadays, some regulatory ecosystems are depicted on the slide. Consumer law with yellow, platform law with red, AI law with green, and you can see the khaki-colored cyber security ecosystem, which is growing and high speed. We mean by regulatory ecosystem the set of regulatory instruments which evolve and interact with each other in a specific environment, namely, in our case, in the environment of digital economy. Of course, further ecosystems can be added, as you have already, I think, guessed, based on the further colors, but outlining all of them, the map would become absolutely chaotic, if not yet. Why is it important from compliance perspective to adopt the regulatory ecosystem approach? In most of the ecosystems, some kind of EU legislation is still in progress. From a compliance point of view, the planned and the ongoing projects have to take into account these future regulatory expectations, and there is a significant set of rules which is highly technical, so compliance tasks consist a great part of in-house translating legal and technical issues and reaching a common denominator of law, technology, and businesses. In the context of regulatory ecosystems, some overarching regulatory topics can be identified which are connecting the regulatory ecosystems. Ranking and open interoperability may serve as a very good examples which have very strong roots in antitrust, but at the same time, they can be encountered also in the DMA, as we could see in the previous presentation, and are interconnected with many other ecosystems. Given the time limit of this presentation, let us narrow the scope of the examination to the ranking issues. Ranking means displaying the relative prominence of options in a particular way. Consequently, from consumer law point of view, it is one of the most important online tools and elements designed to orientate e-consumers, which means to directly lead the users to the relevant digital space. The design of how information is framed and displayed is a key issue also in the consumer decision-making process, and usually extends into the design of digital products. So in the value chain, in the whole line of the value chain, this issue is relevant. In the age of platforms, in cases where digital trade is vertically integrated and operators offer certain products or services to consumers through their own platform services or through traders over which they exercise control, as we know, antitrust and platform regulation responsibility may also arise for organizing the context in which consumers make decisions. At this point, I think it already became visible how difficult it is to grasp the essence of ranking. It can be listed among the information goods that provide information about other products and services, having a direct impact on the competition in the markets for those other products and services. Further, in the context of the internet value chain, ranking can be considered as a gateway which is shaping users' experiences and behaviors within the internet ecosystem. Since by allowing users to interact with the internet ecosystem to create, offer, or access new applications, contents, or services, these enabling and discovery tools have a key role to ensure the openness of the internet ecosystem. Moreover, it comes from the particularity of modern digital trade that platform markets serve as a vital gateway for businesses to reach potential consumers. Leading antitrust cases, which were also referred to by András, where these cases, like the Google Shopping case, call the attention to the fact that differentiated or preferential treatment in ranking may qualify as self-preferencing, a conduct which has an anti-competitive effect which arises from the interlinkage between choice architecture and end-user behavior. Well, as for the Google Shopping case, I'm quite sure that we can open a debate at the end of this panel on the insufficiency of competition law, and I invite the audience being present and online to join this issue as well, if I can offer a topic for the debate. But returning to my subject, the consequences in terms of ranking, the DMA created requirements to the gatekeepers. They have to refrain from treating more favorably those services and products which are offered by the gatekeeper itself or by the controlled traders compared to similar services or products of third parties. And they have to apply fair and non-discriminatory conditions to ranking. To conclude my presentation, from a compliance-based approach, I think, we may state that identifying overarching regulatory topics which are relevant to the business and operation models of market players may serve as a very useful tool to identify and evaluate regulatory risk in the digital regulatory environment and to understand the essence of regulation of digital markets. So thank you very much for your attention and looking forward to your questions.
Thank you for the very complex overview of the issues, and this map is one of my favorites, so you can really see what I will also be talking about, how complex this became. Now we have the pleasure to welcome Nuno Castro Marques from Porto, who is both teaching at the Law Faculty and the Faculty of Economics, and is also an eminent researcher at the Research Center and a member of the editorial board of the Journal for Regulation, right? So we really have a pleasure to also have someone who can see the complex issues. For those who are online, they can comment on YouTube, they can ask their questions on YouTube, which we supposedly will be able to read, and then also discuss.
You have it, the tape. Okay, yeah.
So many thanks. So it's great to be here. Sorry. It's a pleasure. Congratulations on the conference. And my slides are 100% human-based. And so I have a lot of slides, a lot of phrases, human diversity. So sorry, time compliance, but I'll try to stick it. And I'm trying to get to the basics because this is quite complex, and get to the essence is always important to see if we can sort it out. First things first, humans have doubts, and we don't know about the goals of competition. For more than a century, we are discussing them. And when we don't know the goals of competition, we don't know the boundaries between competition and regulation. If we give a goal to competition law, we either strengthen, enlarge, or narrow the field for competition, and on the other side, we expand or reduce the field for regulation. And that's precisely the case, but it has been the case for more than a century, discussing on competition issues, and so we don't know what would be the final goal for competition law. That's the first thing that we should always keep in mind. What we know is that digital markets are new in the sense that they are evolving a lot, using a lot of data, and trying to use also personal data and getting also some market power as they get, it's a question of size beget size, when the importance of the economic power is the result also of the data that they are increasingly using. So it's a question and a deja vu, because when I started investigating about these issues, I remembered that in the year 2000, we would have a crash in the world. All the computers were going to shut down. And when the internet arrived, all the banking system, financial system, etc., was in a crisis. So we are living in technological shocks for decades, and we should pose the question that is really this time different, or the traditional figures that we have are sufficient to tackle with the problems, even if we need to modernize them, okay? So we should try to go to the basis and to the grounds to see if we can fit the new challenges to existing solutions, even if we need to evolve these solutions, okay? So that's my point of view and my challenge to be. So the beginning of confusion is when we start, as we already discussed this today, when we start, for instance, in Facebook cases, using personal data as an issue for competition cases, okay? And we started to mix these situations, and the Facebook case in the Bundeskartellamt 2019 is a paradigmatic case. Bundeskartellamt needed to explain why that was a competition case, and they say, okay, data-driven products need to the input of data, and data is important either for data agencies or for competition agencies, and they try to sort it out, but it's not a clear matter, as some try to defend. And then we had a big confusion. What is big data? When are we facing big data? Can we define big data? We don't know how to define competition. Okay? What is competition? What is economic regulation? And do you know how to define big data? When you have a problem with big data, when you should intervene, you need to have this kind of clarity to intervene in the markets, and so we are adding confusion on confusion, okay? And so we still don't have answers to that, and I don't think that ChatGPT knows the answer to that also, okay? But when does it becomes problematic? When should we intervene, etc.? Bundeskartellamt again changed the law, saying, okay, when I facing problems, I want to make an ex-ante intervention. And so I can declare a company to have a transversal competition market power in all fields of economics, and then allows me to have a speed-up intervention without trying to prove harm or something like that. Okay? And then you have a competition agency transformed in a regulator. Okay? And that's quite a confusion with that. Okay? And then, if you don't know the answers, you go to artificial intelligence and you try to get either a bigger problem or a bigger solution. Question is that we know that artificial intelligence is good for humanity if it brings good solutions. It can be a chaos if we don't manage to control it and to try to understand when they are causing harm to society. What are the risks for artificial intelligence? We have a lot of papers relating for competition problems arising from competition from artificial intelligence, algorithms making collusions, etc., etc., etc. But what is artificial intelligence again? When do we change from big data with this huge capacity of taking out patterns and behaviors, predictions, etc., to this kind of artificial intelligence, which is independent decisions made not by machines? What is machine learning? We still don't have this kind of definition, so we are also with that problem. So what we have now, we have this kind of mix approach because we are fear. We always have fear of what we don't know how to handle. And so we try to a little bit of competition, a little bit of regulation, without being quite explicit what we are doing, because probably we don't know what we are doing. Okay, that's the problem of it. Okay, so let's go to basics. If we accept that economic regulation is to tackle with market failures, we should seek if we are facing market failures in digital markets. If so, we have a clear path to go and leave competition law to what is its field and try to get economic regulators to understand big data, to understand intelligence, artificial intelligence, and to make their way, okay? Because that's what we need to, I suppose, that's my position, okay? Okay, let's try to see. The enduring debate is also the difference between competition and market structure. When we don't know the difference between one and the other, we are always messing up, okay? We know that competition authorities have an intervention in market structure through mergers. But the direct intervention of competition authorities, otherwise than mergers in competition structure, is quite limited, or should be quite limited, okay? We should leave, if we have a market structure that has a problem because of market failures, we should keep the solutions to economic regulation, okay? And that is important so that the competition authorities keep their power, okay? Otherwise, they start discussions about markets and about policies that are endangering their autonomy and independence to act when they need to act when they are facing an infringement, okay? So we have to be clear on that. Without clarity, we just don't have a sustainable intervention in the markets, okay? But we also don't have a new definition for what are the market failures. So we are still working with 20th century definitions. Let's see if they are applicable. Regulation aims to mitigate undesirable results from market failures, okay? What we are facing here, or probably we are facing here, is externalities, information asymmetry, and risk and uncertainty. What we should do is try to understand if we face them. I'm not going to enter in this kind of discussion here because I don't have time, but at least leave it here. And network effects also. The syndrome of missing off or syndrome of missing out, it's the clear evidence of network effects. Okay, if I lose my contacts in my network, social network, what will I do with my life? So that's the lock-in effects. Everything is there. So we have to extract the consequences there. Then also, when you add artificial intelligence, you add risk and uncertainty to the equation, and so you should try to see this. Information. We live in a world of imperfect information. If we had perfect information, we would have perfect competition, and we wouldn't need regulation, and most probably we wouldn't need competition authorities because perfect information would solve it with our behaviors in the market. But the fact is that we don't have it. Okay, and so we need to tackle with that, and also with the consequences of that. We need to remember that regulation is for establishing rules and supervising behaviors. Competition authorities is to tackle with infringements mostly, and so we would also benefit from that clarification. But also, as we already said today here several times, is that regulation today is accepted also to address other problems, just as power economic problems, political problems, public services problems, etc. So regulation is expanding in this new generation, also social regulation, which is more and more accepted. Certain aspects of digital markets and artificial intelligence are presenting typical market failures, okay? And we have to be clear on that. We have to assume that it's most probably that lack of certainty which is also causing problems, because we are seeing a lot of people discussing what is the real nature of Digital Markets Act. If we had this kind of clarity, we wouldn't have this discussion, okay? What is the nature of the Digital Markets Act? It's a regulatory one. Yes, it is. We'll see it clearly for that, okay? So, if it is, our question would be different, or should be different. Why digital markets are not yet regulated, or have not yet been regulated for several years? We are now discussing economic power of certain companies that should have been regulated priorly before achieving such an economic power, okay? So it's probably a chicken and egg problem as usual. Some say that Digital Markets Act is to tackle with market failure typically addressed by competition law. I don't agree with that. Economic regulation tackles with market failures. Competition law shouldn't tackle with market failures, okay? It's on the market structure that competition surges, and we should intervene on that. So we should try. Also, Digital Markets Act is talking about gatekeepers. If we are regulating, we regulate markets. We don't regulate companies. That's another error. It's obvious that now we are running on the prejudice. We are running after GAFA, Google, Amazon, Facebook, and Apple, okay? But we should be thinking about regulating markets, not about regulating 3, 4, 5 companies. The United States had a proposal for ICOA. It's a similar regulation of Digital Markets Act, and it failed. And Professor Ovankamp criticized it rightly because it also was using the definition of gatekeeping, and he said it's not for companies, for markets. So we should change the model. Okay. It's obvious that Digital Markets Act says it's regulation because it talks about network effects, lock-ins, economies of scales, etc. When we talk about this, we are talking about regulation. We are not talking about competition. It's obvious that this kind of inputs are also important for the competition assessment. If you have a lock-in effect, it's important to the evidence of the economic power or market power. But we should be assessing it in a dominance case, okay, unilateral case, or in a collusion case if we are artificially changing the parameters of the market, but not as an ex-ante intervention, okay? Or, again, if we are talking about mergers, but that's a different case, okay? Here, we are trying to regulate behaviors, unilateral behaviors of gatekeepers. So we are talking about that different situation. Also, OECD made a study, and they made a proposal that I think that is balanced. Data should be an input for competition law, but digital markets need to be regulated. Okay? And also artificial intelligence need to be regulated. This week, Commissioner Verstappen made a public announcement saying, okay, we are late on regulation for artificial intelligence, so let's do. And also the Stigler report made in the United States made an assessment on the problems of digital markets. We'll see what are the problems. And the European Commission says in the white paper about artificial intelligence that the harms from artificial intelligence go well beyond the markets reaching fundamental rights, etc. So we need to intervene, and that's not only for competition law. If we have typical market failures, we have nothing new. What we have, it's new technology which can still be brought to old problems with new names, but old problems. We need to see if the old instruments are still capable of taking care of the problems and be clear on the pathway to start doing our job. That's the most important situation, okay? It's clear that Digital Markets Act, it's not competition law. We have the Nebis-Needham problem solved. So, as we already saw here today, we are going to have fines for competition law infringement and also fines for Digital Markets Act infringements, up to 10% of the worldwide turnover, okay? But we see that it's an act that is directed for 3, 4, 5 companies in the world, so the rest of us not being protected by that act, okay? Let's be clear on that. But the question is that should competition law have their goals broadened to also include the question of digital markets? No. We should see digital markets as other markets with market failures, try to sort the problems that they have in their structure, and then put competition law, the general competition law, acting on the collusion, on the abuse of dominance, etc., etc., etc. Okay? I'm not saying that's simple, but at least we should start. If it's like that, then digital markets have a problem. It's not a problem with its nature, it's the problem with the model, because it is a centralized model. That's my conclusion. Only the Commission has the powers to enforce the Digital Markets Act, to start investigations, to define what is a gatekeeper, to impose obligations, to impose sanctions, etc. It's an old model that we had in Regulation 1762 of competition law. We changed it in Regulation 1/2003 with decentralization of European competition law. And now we are having a Digital Markets Act that is thinking about centralizing regulation. in Europe, saying that member states cannot take its own measures except if it is to tackle with other interests. Okay, no problem with that. If the regulation is only to maintain or to create a market structure, well, we could discuss on this centralization functions in the European Commission, on this general discussion about the trend of centralization in everything in the European institutions. But, as we said already here, if regulation goes beyond market structure, then we have a problem. Because member states can only act if they don't violate the European law. And who is going to see or declare if the member states are, or the measures that member states are taking, violates European law, is going to be the European Commission. So we've seen it already in the merger regulation, when member states can act on their national interests if they are fundamental interests, and normally that's a norm that is not applicable. It's there in theory, but it's not there in practice. So we can face there a huge problem because we don't know what is compatible with European Union. Stiegler committee pointed out that digital markets puts a problem of concentration of economic, media, data, and political power. So we have there fundamental problems that need to be addressed with the proper instruments, which, in my opinion, is not solely competition law. So what Keynes teaches us a long time ago is that markets tend to equilibrate, but probably in the long run. And in the long run, we are all dead. So we should start, when we have market failures, we should start to regulate them in the present so that we can have competition law. The problem is that to have good policy, not over restrictive, not over permissively. It's a good policy that we need for the digital markets and artificial intelligence. So thank you again. I hope that you enjoyed. Thank you.
Thank you for the excellent presentation. I completely agree. So, do you have any questions from the audience to the panel? Henry.
Okay. So if I'm not mistaken, I look at the presentation of Andras, and he paid attention to what to regulate, and Nuno come up with the model. So if you can answer what Andras trying to do, because he's really concentrated to what to regulate, but you come up with a model, since he also arguing two model data that need to be regulated. One is all data which is monetized, commercialized, and the other is personal data. So if my question is, can your model apply to what Andras tried to answer? Just my question. Yeah, thank you.
I expect so, because one of the first things for regulators to make, the first thing for the state to make, is to define clearly what is the objective of a sectoral regulation. So, the first thing that when we talk about economic regulation, we are talking about definition of a formal and a substantive model to apply to a sectoral of economic activities. And then a regulation is quite strict in what it can and cannot do, because it's independent regulation. If we have the full nature of economic regulation, the regulation shouldn't substitute or be a substitution of legislative powers, etc. So, and democratic powers, etc. So it's an economic, technical, independent regulation. And the first thing that we need to have that is the concrete objective of the regulative or the regulatory intervention. So, first thing and the first challenge for a regulator would be to define what is big data. That would be a huge progress now. And the second thing would be, for instance, to define what is the possibility of use of personal data, for instance. And we have already some, at least in Portugal, and I suppose that in Hungary also, you have already some national agencies doing that job. But what we would need is to have transversal definitions that all would at least apply. We could always evaluate with those definitions. It's a trial and error system. And based on that, you have a level playing field of the market. On that level playing field, you have competition law, and you have the control of the behaviors of the market agents. So I suppose so.
Judith?
If I may add, the starting point is that I fully agree with this creation of models which you outlined. But I'd like to add that a model can be based, as you said, on definitions. And what I see in our major problem from the market actors' side, that how to understand these definitions which you already have, and to define which are the definitions which we really need. For example, I can add to the list of the missing definitions the definition of platforms, because we have a highly technical definition in the DSA, but we see that platforms have a coordination function in multi-levels. So I would like to emphasize the translation job to be done between IT and economics, because I think that the successful regulation in enforcement, I mean to use it in the daily life, it's very important that market players can understand and apply the definitions with which models are working with. And I see this very cornerstone part of the model still missing.
Mm-hmm. Yeah, I fully agree.
Thank you. Any other questions? Yes, one from András.
Yes, I would like to ask a question from Sophie. I don't know whether she can hear me right now.
I can hear you.
Hopefully. So thank you very much for the presentation again, that we could see how the implementing process of DMA goes on. And my question would be just whether you have already any experience with in communication and working together with future gatekeepers. Do you have any experience with them already? That was my question. Thank you.
Yes, I'd say even on several levels. So we engage with gatekeepers bilaterally, discussing mostly at the moment the way the core platform services are delineated. And then we also engage multilaterally. I'm not sure you're aware, but we have organized a number of workshops here in Brussels, bringing together gatekeepers, but also business associations, other third parties, researchers. So really bringing together different kinds of stakeholders, discussing how certain obligations can and should be implemented. What are the challenges? Some of the gatekeepers even made some public proposals already, obviously on a high level, and not in the detail we would have hoped for, maybe. But so certainly this engagement is starting, and I'm sure it will develop further in the months to come, and once we have actually designated gatekeepers and are really engaging in more detailed talks on how to implement the obligations.
Thank you. Yes, one question.
So thank you for the chance to have a question, and it's about the empowerment of the consumers. I think that was a really strong sentence, because on the field of data protection, we already see attempts to somehow strengthen us, like through the Data Governance Act and the Data Act, which basically provides us as consumers or as data subjects a right to have direct access to data which is generated by the smart machines we use. And what do you think, all of you? We heard that competitors should have access to big data that is being generated by Google and the other possible gatekeepers. Why shouldn't the consumers have access to it? And it's a rather complex one, and maybe we don't have time for it. But.
Anyone would like to start?
Oh, well. It's a great question, because in a competition point of view, data is an input, and if you are generating data by your activity, it's your property. And then you can only impose access to that data if it is defined as an essential infrastructure. Well, we are for decades discussing the concept of essential infrastructure on concrete situations, not on digital situations. So it's a major problem there. So you have this European Court case law from decades saying, okay, it's not, you have to have several criteria to define an essential facility. And so we don't have access to that data because it's being generated by Google's activity, period. Okay, so it's mine, it's my activity. Why should you benefit from my work? Okay, this kind of discussion is a discussion about regulation. Okay, and so you should regulate this kind of situation to define first what is big data, and afterwards what to do with big data. Okay, and then the protection of big data, how to create big data, what are the conditions to create the big data, and what should be the conditions to access to big data. As for instance in telecoms and everything, or waste, etc., you have regulation about, we don't define it as essential infrastructures for competition, but infrastructures that can be used by everyone. For instance, conducts and everything that all the companies should possibly use to have access to the market. That's not a competition problem, it's a regulation problem. As we don't have a regulation still in place, you don't have the answer.
Judith?
Yes, thank you very much. I agree that there are multiple levels of this issue. We have seen an argumentation from Nuno about the right to decide on data. And I would like to add the dimension, what is the value of the data? Because we can see that in the business-to-business flow, data flow, heavy money is paid, because we need the data to feed AI in the digital markets. But I think that, okay, if we accept that as a natural person I have the right to decide about my data, there are situations where this data may have a value, and I could make an economic decision on the access of my data. And I think that's also a part of the whole picture, and as a part of the empowerment of e-consumers. What is the value of the data in the business-to-consumer segment?
Thank you. My view is that individual consumer protection should be left to consumer protection and all the regulation concerning individual consumer protection. So when we regulate competition or when we deal with competition issues, it shouldn't be about the individual consumer who is harmed. Just look at predatory pricing. There are consumers who gain because prices are low. Then you have consumers who lose because then prices will be increased during the recoupment period. So we don't care about consumer A or B. We are concerned about consumers in general, just to put it that way. So I would, that's my opinion. So we shouldn't protect the individual consumer. That's for someone else.
But maybe to add from the DMA perspective, sorry if you can.
Yes?
To add from the DMA perspective, so there is actually two provisions that do provide some sort of, not access to data, but basically ensures a certain autonomy for end users to control their data. So there's Article 5.2, which I mentioned, where consumers will, or end users will be asked for consent about combination and cross-use of their personal data for certain services. So that's where end users will have the power to say no, for example. And then there is the portability obligation, which ensures that data is not accessible to end users directly, but they are able to control, for example, that third parties can use their data to provide them a better service. So there, in that sense, the DMA also engages the end user and gives them some control.
Thank you, Sophie.
Thank you for the exhausting answers.
Thank you. So I think we are 2 minutes over the time limit, which is great. So we kept basically the time limit. Now we will have a short coffee break, and just because there is also audience online, we will start exactly at 11:30 after the coffee break. Thank you so much for all the panel members, all the questions, the audience. So I think we set the scene. We have heard very strong messages from the National Competition Authority. So listening to that, I see completely new world coming, and we have also seen the theoretical, some aspects of the theoretical background. So I'm really looking forward to the rest of the day. Thank you, and let's have a coffee.
Thank you.
you. Hello. Siedai poi.
Lemaradt. Dear ladies and gentlemen, dear conference audience, we are about to start our next panel, which will consider whether the regulation is to the right way. And I'm very happy to introduce our first speaker in this panel, who we well know. Pál Szilágyi is the director of the Competition Law Research Center at this university. And Pál will speak about whether one step forward, step back, regulators overacting. So Pál, the floor is yours.
Thank you. So, thank you so much. I'm a very sad and confused professor because I teach competition law, and nowadays it's very difficult to keep sight what is actually happening with competition law, or whether what is happening is competition law at all or not. So we had excellent presentations on the limits, whether something is competition law or not, but still there is lots of confusion present currently. Also, I'm sad and confused because if you have a business and your competitors are faring better than you do, then what do? You can sabotage them. That's not nice, right? Or you can see what they are doing better than you do, what you do. And that's something which I don't see in European regulation, because if we look at the other market, then we see that the regulations we have introduced are not present there. They have, of course, that's a different continent, but nevertheless, still there is a bit confusion about that. Just referring a little bit to the history of competition policy versus industrial policy here. Also, I'm confused, not sad, but confused, because when you look at all these new things happening, and then you look at the courts cases, then you see, well, there is not so much happening yet, at least. Okay? Just look at the recent Apple Epic judgment from, I think, last week, or recently, where the courts said in the US, well, Epic could not prove that consumers are not willingly buying themselves into the Apple ecosystem. And since that was not proven in the case, well, where is the consumer harm? It's not proven in the case because maybe, we don't know because that was not proven in the case, maybe consumers are willingly buying themselves into one of the ecosystems, and then whatever happens inside, that might not be that bigger problem at all at the end. Of course, the case is much more complex than this, but it also leads to the confusion because there is heavy regulatory push on the one hand. On the other hand, we don't see that translated to actual competition law yet, like court cases. Okay. Also, primary law cannot be changed by the Commission. So whatever the Commission thinks is right will be tested under the competition provisions at the end before the European Court of Justice. So we will see all these things. I'm trying to keep my time limits. Please let me know if I only have 5 minutes left.
Right.
Okay. So we have a long history of antitrust enforcement, like more than 100 years, together with the US. And we had competition law in peace, in war, in crisis. So we have seen it all, basically. We have seen different markets, different monopolies. We have tackled Rockefeller, right? The largest, it's top 10 richest people in history, okay? Rockefeller. So we have seen already large corporations, and we used antitrust law to deal with problems present there. So we have seen plenty of issues in competition law, and probably we could say up to 5 years ago, in the last 25 years, we have seen a very coherent competition policy. We could see there is consumer welfare on top of the goals, and yeah, something else always there, like a little bit of protection of competitors, consumers, market structure, whatever. But the main issue was consumer welfare. We also had a cyclic evolution between competition policy and industrial policy. So looking at history, we see sometimes industrial policy was stronger, especially in the US. It's very, very easy to see under which president which policy was stronger, competition policy or industrial policy. And we also had extensive debates on the goals of antitrust policy. So there is very few things left to say here. So what should be, or what could be, the goals of antitrust policy. What we have seen, however, in the last 30 years, that there was a little bit of focusing too much on cartels, in my opinion. Okay, so EU antitrust reform was just look level of fines. Let's increase the level of fines. We can see the nice graphs, tenfold increase in fines. Okay, commitment decisions. Okay, too difficult cases. Let's make the undertakings interested in not fighting before courts, so they will get a reduction in fines at the end. Leniency policy, cartels, secret. Well, how can we detect them easier? Antitrust damages actions, we have a presumption on the harm caused by cartels in Hungary, and all the relevant and associated issues. These were mainly related to, not solely, but mainly related to cartels. And there were some large fines. We had the Intel case, we had the Google cases recently, okay, but not so much was in competition policy about Article 102 than about Article 101, which probably also led to the current situation, under enforcement of Article 102. The guidance paper is just revisited now, okay, almost 20 years after it was issued by the European Commission. We had very few merger decisions. And now suddenly competition authorities start to realize, okay, we allowed mergers 10 years ago. Let's see what we can do about the mergers we allowed or not contested 10 years ago. Maybe we were wrong 10 years ago. That's a lot of time in competition terms, I would say, especially on these digital markets. So I also listed some other issues like dealing with oligopolies, 5 to 4, 4 to 3, 3 to 1, where should we draw the limit, in principle at least, and so on and so forth. All these led to the under-enforcement of competition law, I would say. We have heard about fines being not enough, not large enough. I am a long-time advocate of higher fines. Maybe they could have been enough if we used the theoretical maximum, like worldwide turnover 10%. That's the theoretical maximum of fines. We usually don't use that. We localize the problem and issue fines based on that, but we could have used. Okay, so the current situation was also created probably by the difficulties of competition enforcement. Okay, we have long cases, long time period. So a commission case can take 5, 10 years. So, okay. Then you go to the General Court, then you go to the European Court of Justice. Until you have a final judgment on the substantive issue, you don't know what actually the law is. Okay? You have a commission decision saying this, okay, but I don't think that's the law, so let's go to the courts. And then we end up 10 or 20 years after the problem occurred with an answer to the problem. Well, this is the law, this is how you should have done it 20 years ago. In these markets, 20 years, long time. Litigation is very complex in these cases. Okay? This is, of course, one of the reasons why we have so long, why the cases are so long. We have complex factual questions, economic evaluations, legal questions, fair trial rights. All these made litigations very complex and time-consuming. One of the reasons probably for the DMA was that, well, competition cases take too long. So let's do some ex-ante regulation. Let's deal with these cases. But these cases take too long because this is how it evolved according to the European Court of Justice. This is why we have fair trial rights, because this is how you can ensure protection, fair trial rights protection. Okay? We could have much easier competition cases if we didn't have all these problems in a competition litigation where we try to see whether there is a competition problem or not at all. Okay, so these take a long time. On the other hand, we have a rapid development, like digital markets, extremely fast. Okay? Rapid growth I have on my slide, but really? So yes, we can see that Netflix, it took 3.5 years to reach 1 million users, for ChatGPT 5 days. Okay? But how many more citizens are there all over the world? How many more internet users are around the world? Many, many more. So maybe just the absolute numbers are misleading, because at least we should look at the percentages. So like the internet users, how many number of the internet users or percentage of the internet users are actually concerned by a particular market behavior. Isn't rapid growth also meaning rapid fall if consumers dislike your product? If ChatGPT can reach 100 million users, monthly users, in 2 months, isn't that also meaning that the competitor can lose also so quickly its place on the market, right? So not only rapid growth, rapid fall can be also something which we should consider. Extensive profits. So one of the arguments, well, there are monopolies or there is market power present, leading to excessive profits, extra profits, however we would like to call them. But actually, these markets are not among the most profitable markets. Okay, there are more profitable industries all over the world. So this is nothing like the first or the largest or the biggest, okay? We have other industries which are more profitable. Enduring market power, a typical argument. Really? Is there really enduring market power? In our lives, 10 years is a lot. In a competition case, it's just half of the case, right? So sometimes it takes 20 years. Okay. But on the market, probably 10 years, that's not a long time. Okay, and if we look at economic theory, we already mentioned several times Schumpeter. Well, sometimes the markets to work need time. And at the end, we might come at a nice result as a result of market forces themselves, so without regulation. Because these time periods, again, are maybe not so long than we think in the time of TikTok where, well, 3 minutes, that's too long, right? So 15 seconds, that's a better TikTok video than 3 minutes. So what were the reactions to some of the issues I highlighted, but there are hundreds more? Well, in the EU, we have regulation. We have seen my favorite map from Judith, extensive regulation, many areas. Today, of course, we are focusing mainly on DMA. We have heard, and I completely agree, this is not competition regulation, I think. So DMA is not competition regulation. That's also my point. It's regulation, but something else. And well, my last point here is that isn't there a danger of competition authorities becoming schizophrenic, like dealing with all these issues for which they don't have 100 years of experience, for which they maybe don't have the capacity and or the knowledge. All this can be, of course, solved by the state, so you can give more money, more people, more education to the competition authorities. But still, several issues we are trying to deal with here need maybe different capabilities than competition authorities currently have. In the US, we have a new antitrust under the new head of FTC, so we can see challenges which are new, let's put it that way. So courts are currently not really reflecting on that, we can see. So there isn't a big success yet with the new antitrust over there. So one of the concerns I'm again highlighting is that competition law might become a seedbed for different other policies for which competition authorities are not trained yet. The most obvious ones are environmental policy. There is a big push to include environmental policy into competition law assessment. I'm a big opponent of that, not because I don't like environmental policy. I just think it's not for a competition authority to evaluate competition policy the environmental policy issues. Labor law, very new, very fancy subject in competition law. Again, probably labor relations, employment, economics of employment are not something for which competition authorities are well trained. And of course, we have industrial policy as a usual suspect in competition law. Recently, and we have seen references to that, we also see that competition law is used, well, it's not a fact, it's just a feeling, to tackle other types of problems. Data protection. Why didn't the Irish Data Protection Authority intervene regarding Facebook? So the German Competition Authority did it. Okay? There is a problem with democracy, like views are not colorful enough on the social media, or they are directed into one way. That's not really a competition issue. Still, we see competition law used to tackle problems which are not closely associated with competition policy. Okay? And there is a nice phrase, to regulate competition, you must first attract it. So most of the designated gatekeepers are US companies. Somehow this happened. Okay? So we don't have those companies which are competitive enough, which are on the competitive landscape to be regulated. So we regulate US companies mainly. Of course, there is Booking.com, for example, but nevertheless, one might be cautious not to overreach with regulation when we try to regulate all the very important issues that are present in the DMA. I think I have basically no time left, so we can see that there was a big push, like Bork, we can say, okay, Chicago school, old school, so was very important, is very important. We know a lot about competition because of the Chicago school, but probably that won't be the main focus of competition policy anymore, like efficiency, efficiency, efficiency. Of course, oversimplified. Schumpeter, it seems like it's not on the top of the list. Okay, so currently, long-term innovation is not what is the first priority. So we try to look 1, 2, 3, 5 years ahead, not 10 or 20 years ahead in time. I can see a little bit of structured conduct performance paradigm revived, like structure of the market is important to have competition. Okay, so that's probably something we have to reread again what was written on these subjects. And that's my final message. I'm more like provocative today than dealing with specific cases. So if you have a hammer, then you shouldn't treat everything as a nail. We should clearly define what a nail should be or is, and only hit the nails, not our fingers at the end. Thank you so much for your time, and that's it.
Thank you very much, Pavel, for this wonderful presentation, somewhat provoking or broadening the perspective at least. Now I'm very pleased to introduce to you Professor Kerem Sanli from the University Istanbul Bilkli University. Professor Sanli is a professor of competition law, teaches also contract law, the director of a competition law and policy research center. They do also economic analysis. And Professor, the floor is yours.
Thank you very much. I think I need to change this first. Oops. This is my presentation. Okay. All right. I start thanking I'd like to first thank you for organizing this event and inviting me here and hosting me here in Budapest. It's great to be here, wonderful hall. So another thing that my topic really fits well within the framework of this session. So the Turkish law is probably irrelevant for most of you, right? It does not inspire other countries in terms of regulation making or law making, but there might be some lessons, because the law that we have made, that we have just enacted this summer, it aims actually to control the economic problems, competitive problems of digital platforms. But what I will claim here is that it's not going to be successful, and you'll probably notice that the provisions of the obligations set out in the law are not sound. They are rather odd in terms of competition policy, and the law probably will increase the compliance cost. It will stifle competition. It will hamper innovation and that sort of thing. So the result will be bad. So this is a bad example of regulation. That's why it fits well within the framework of this session. So let's start. So I will try to show the oddity of provisions and illustrate how ambitious the lawmaker can be and the bad results following that. I'll talk about the current approach a little bit, but my focus will be the basics of e-commerce law, and I will criticize the law. Basically, that's what I'm going to do here. So there are apparently good things about law. Not everything is bad, but what I'm going to talk about is rather bad. So I'll pick some provisions and talk about them, right? So we already discussed these issues here. I'm not going to talk about it. So the current atmosphere surrounding the digital platforms is that we should be more interventionist, right? We should apply competition law more vigorously, and that is not enough, so we should regulate them. That's what you have criticized just moments ago, a little bit at least. So that's what the Turkish approach as well at the moment. I can clearly state that Turkish Competition Authority is one of the most active authorities in the world dealing with platforms. We have over 20 cases, infringement cases, dealing with digital platforms, and most of them are novel cases, like unfair pricing, price parity clauses, both wide and narrow. And that we have a case about data portability. I don't know whether or not you have a similar case like that, and it concerns a second-hand book dealing platform. Very small platform, but it's a monopoly in its market. It's narrow market. So we have a lot of cases. That's one thing. Something is happening. No, is it still me? Okay. All right. There's no one there. we are on our own. All right. So not only that, not only those cases, but we have various reports. Something is going on here.
Maybe just move the microphone a bit.
Like this?
Yeah.
Okay.
Hopefully, yeah.
Like this? All right. Oh, too close. All right. Still there. All right. All right, I'll continue anyway. So there are also market studies going on. There are 3 reports on marketplaces. There's a report on digital advertising, which is like 400 pages. It's a huge report. And there's also another report about digital payment systems. And there is an ongoing study on mobile ecosystem. So what I mean here is that our authority is very active, and there's a lot of expertise and knowledge from the market. But still, those decisions and those studies were not enough, so our lawmaker intended to regulate the issue with a separate law. There were 2 drafts were prepared last year. One didn't go through to legislative process, so it's still draft, but that was a sound draft, which I'm not going to talk about. The other one was not sound, but it was enacted as of last summer, July 2022. So it's not a total new law, it's an amendment. The original law was about transactions between the consumers and platforms, and it was like some sort of consumer protection law. So platforms had some obligations and still have some obligations to inform the customers, etc., etc. So it was about a consumer law. So the purpose of the amendment was explicitly to address the monopolization and economic problems caused by the platform. So the lawmaker, in its preamble, explicitly stated that there's a concentration problem in platforms due to these economic conditions. So I'm going to regulate the platforms, and my model is some countries, Europe and elsewhere, and I will set out some new obligations for platform in order to curb their economic power and to create competition. So if you read the preamble, it looks like it's DMA, right? So That was the preamble. So it has three pillars. One, it prohibited unfair commercial practices. So this part is sound. It resembles to P2B regulation. I'm not going to talk about, but it's sound. The part that I'm going to talk about is the obligations that are brought for the digital platforms. There are like 18 new obligations, and the aim of these obligations was to create competition. So it's a competition policy tool for the lawmaker. And there are other rules like monitoring, like information rules. Maybe I should underline that here. The lawmaker has made interesting enforcement rules, and it set out very harsh penalties for infringements. So it's a drastic change in the law in terms of both scope and the aim. Scope, it applies to apparently digital platforms. But what I mean digital platforms here is not all digital platforms. For example, it only applies to transaction platforms. So non-transaction platforms like social media platforms, ad platforms are not within the coverage of this law. The reason, we don't know. There is no explicit explanation for that. Second, some industries are exempted from this regulation, like travel industry, tourism, civil aviation, financial industries. Reason? We don't know. We have no idea what characteristics of these markets result in the lawmaker to think that this new law is not going to apply to these industries. We don't know. So what is the structure of the act? Well, there are some obligations for all platforms, irrespective of the market power. So it doesn't matter whether or not you're a gatekeeper or you have a monopoly, you're burdened with these obligations. And there are other obligations which somehow we can relate them with market power. There are some financial thresholds. So, well, these financial thresholds this is an anomaly. The financial thresholds are based on transaction value. So if you exceed certain financial thresholds that are set out in the Act, you are encumbered with the obligations. So there are 3 thresholds, interestingly, not 2, not 1, but 3. So there's one for 15 billion Turkish liras. I don't know what these numbers mean to you, but I just wrote down the US dollar equivalent. 45 billion Turkish liras and 90 billion Turkish liras. So there are 3 thresholds, so meaning that at least 3 types of obligations and 3 types of platforms. Somehow these thresholds are or should be associated with market power, but as we know, market power is generally a binary thing, right? Either you're a gatekeeper, you have the market power or not. So we understand the logic of the quantitative criteria, right? But 3 thresholds don't make sense. So when we look at the nature of the obligations, which I'm going to just explain in a minute, they are similar to DMA in terms of characteristics. They are rules, not standards in terms of law and economics, the terminology. They're applied without due consideration of effects on the market, so we don't do an effects analysis. And there's no objective justification or no efficiency defense, nothing whatsoever. If you exceed certain thresholds, you're burdened with the obligations. That's what it is. So this is the simple chart. So on the left side, you can see obligations for all platforms. The right is obligations for medium-sized platforms. Next to it, obligations for large platforms and obligations for very large platforms. So interesting obligations. I will just talk about a few of them. Let's start with the anomalies. Now, my criticism starts here. As I said, we don't know why certain industries are exempted from the application of this law. It seems that there's no logic. And as I said, non-transaction platforms are not within the coverage of this act. There is no logic. Again, as we know from economic theory that non-transaction platforms, there is the tendency of create monopolization with respect to non-transaction platforms are actually higher. The probability that it's going to get the market is higher. So the scope is problematic. That's the one thing. The rationale of this whole system of this threshold is problematic as well. Starting with the transaction value. I hope I could make it clear what I mean by transaction value. So it's not the turnover that you get from your economic activity, but it's the aggregate value of the transactions that took place over the platform. So you take a commission from it, like 10%, 50%. So the criterion here is it doesn't make sense in terms of indicating the market power. So why not turnover? Why do we have 3 thresholds and 3 types of platforms? I mean, you have gatekeeper or not. Here we have medium size, large, very large. It's like a t-shirt that you're buying, right? So do we have different degrees of market power in platform markets? Well, I did not witness any. There may be, I don't know. Why these financial figures? So these are magical figures like 15 billion, 45 billion, or 90 billion, or whatever. So remember, these numbers will apply across the board. It doesn't matter whether or not you're a marketplace in selling t-shirts or a marketplace in food delivery. It doesn't matter. It applies to all industries within the coverage. And there is no relation between the financial thresholds and obligations. We cannot understand. How do we relate those, right? Why the medium-sized platform has an obligation to, for example, data portability, why the large one has an obligation to limit the advertisement budget. So these are the structural problems, and basically it's very important. I'll talk just one of them, the PL brand prohibition. So this is a prohibition that is going to apply to all platforms. So without any financial threshold. So what is the prohibition? The platform is prohibited to sell its own brand. So you cannot have a brand. So think about Amazon. Amazon cannot and won't be able to sell its brand. We understand the concern here, right? So there's a risk that Amazon can make self-preferencing, and there are cases related to that. We have in Turkey cases like that regarding the Alibaba, Trendyol. But the solution to that problem is prohibiting the selling its own brand. So it seems harsh, right? A little bit, at least. So that's the main problem here in this provision. It's unproportional. For example, the law. So there you create some value by investing in your brand, and generally platforms are originated from their own brands, right? First they sell brands from online, then they change their business model to platform. So it's a sort of entry barrier as well to the market. And interestingly, well, assume that you don't have a brand, but you buy the brand and sell it through the platform. This prohibition does not apply in your case, but the logic is the same, economic logic. You could do differential treatment to your products in that scenario, right? You can, when you sell your own goods, you can favor yourself by different selling conditions. So that's an interesting prohibition. It's too harsh. It's not proportional. Doesn't have a logic. And now we are coming to other ones. So, for example, there's a cap on advertising budget of large platforms. This is only, we have terms, okay. There's a cap. So, the idea of cap here is that the platforms invest too much money on advertisement, and this is bad for economy. This is bad for rivals, so it's an entry barrier, so the lawmaker thought, I believe. So there's a budget, and those budgets are determined in the law. You have a baseline of 900 million Turkish lira budget for advertisement, and on the top of that, depending on the value of the net transactions through your platform, there will be 0.3% of your that value is taken as a ratio. So we limit the advertisement activity of platforms. The concern is understood. The effect will be negative. This will hamper the growth of large platforms, but the platform competition will be stifled. You won't be able to enter different markets when you want to. Like, for example, you're just selling some products through your platform, and you want to enter the other markets, but you have to make investment in advertisement. You won't be able to do that because your budget is limited. So, economics of scope is a value according to the eyes of the lawmaker. And apparently these are magical numbers. But what is more interesting is this: cap on the discount budget of large platform. So there's the same cap for the discount budget. So you will have a separate discount budget, which will be determined according to these values, the same values that I showed. 2% and 0.3% of the net transaction value, and you won't be able to exceed that. If you exceed that values, then there's a harsh penalty for that. So what is the logic? The logic is that these platforms are losing money, so they are burning cash, and it's a predatory pricing case for them, and so we should limit this with the same figures across the board. Doesn't matter. So is there research on that? Is there empirical findings? There's nothing whatsoever. So the price competition will weaken, consumer welfare will be diminished, there will be price increase, there will be net loss for consumers, etc., etc. There are also interesting obligations for very large platforms. These are the nature of these obligations, which I wrote down there, is that the law actually brought entry barriers with the law, with these provisions. So, for example, they are prohibited from offering financial services to consumers over the platform, and they won't be able to enter into the market of logistics and cargo services. But this is to third parties, not within the platform. They can. There's no logic of these provisions. As my time is limited, I will skip to the last part. This is it. So there's also tax. It says license fee, but this is a pure tax. So I'm not sure whether or not you can understand the figures there, but so there are different thresholds here. And for example, if you exceed 10 billion, you have to pay a certain fee every year. The only condition for the license is paying the fee. That's it. There's no standard whatsoever. But as the transaction value increases, so is the amount of the fee that you have to pay, and by unproportional levels. So if you, for example, exceed 60 billion, you have to pay 20%. So 20% is probably your revenue. You have to pay the revenue as a tax every year. So the logic, don't grow, right? Big is bad. That's basically it. So the effect will be price increase. It disincentivizes the growth and everything. So it will hamper competition. So my conclusion is this. Apparently, I try to. You cannot make good out of this law. It's very bad, and we are hoping that it's brought to Constitutional Court, and we are hoping that it will be repealed. It will be annulled by the Constitutional Court. It's a unique law for sure, and Turkey can make unique laws. It's okay, and you have some different policy considerations as well. But the law explicitly says that in the preamble, at least, that the purpose is to create competition. But this is nothing to do with competition. It's instead of scientific research or findings, there are preconceptions and biased assumptions. It's based on preconceptions and biased assumptions. Oops, this is my timing. Too much advertisement, they do predatory pricing. Advertisement is not valuable. Ecosystems should be choked. Big is bad. These are the values that this law is based on. And it's very easy, according to the lawmaker, to control these problems just tax them. And so it's not that easy, as we all know, as we are dealing with competition law. There are different stakeholders and different values, and you have to keep the balance. That's why we are dealing, that's why these cases take a long time, right? So here we have a very raw and unsound law that are dealing with these issues, and it has nothing to do with fostering competition in the market. It will increase compliance costs and inflict enormous burden on platforms. I think it's a good example. The only value is that it's a good example of how not to do law concerning digital platforms. That's my main takeaway from this. Thank you for listening to me.
Thank you very much, Professor, for this excellent presentation and providing us some details on some critical approach for certain way of doing regulations. Now we will have a presentation from an excellent professionals, academicals, Bayer Philip, and Zsolt Zödi from the National University of Public Service, from the Research Institute on Informational Society, how to do regulation in a right way regarding to the regulatory mind. So, Philip, the floor is yours.
Well, thank you very much. I feel truly honored to be standing on this stage. I'm a PhD student. My name is Philip Bayer. It's a great introduction how to do regulation right. We try to propose a formal approach to that, a methodological tool that is Regulatory Mind. Regulatory Mind starts with a set of problems, otherwise called regulatory ambitions. Regulatory ambitions are a vague set of goals that most of us are familiar with in this room when it comes to the Digital Markets Act. For instance, market tipping and competition for the market is one very good example of a regulatory ambition. We don't yet know what to do and how to do it, but there is a reason there for states to intervene, either with the tool of competition law or with regulation. From a more academic perspective, we could say that there is a surge in the concentration of economical power in our lives, and states are ought to do something about that. So these are regulatory ambitions, and with starting with problems of regulatory ambitions in our assessment, we define our assessment in a better way than if we started with an antitrust, for example, or a certain field of law. How antitrust should evolve is in itself is not a viable question. The viable question is, what should we do about problems that occur in the digital ecosystem? Regulatory Mind was coined by Seung-Jan Shao, who's an American professor, and he used regulatory mind to illustrate how the Chicago School of Antitrust got so big and got so influential. Well, he didn't do it in a manner that was, well, it was respectful, as to say, because he realized that we can. So Robert Bork was a great mind, and he did great. Did a great contribution to the theory of antitrust. And he started from a regulatory ambition, it was market performance, inferred it into a paradigm within the epistemic community that the Chicago School was, a paradigm being a cognitive limit to what are the possible answers to our questions sprouting from the program, the regulatory ambition, which is then inferred into a legal framework which consists of actual legal provisions or standards in case law when it comes to competition law. And through the enforcement of such, we can reach a public sentiment, what scholarship, what laymen think about how the world is changing around us. This is a static framework for regulatory mind. The dynamic one is a hermeneutic cycle, which is not part of our presentation currently, because we will be using the static version of regulatory mind to illustrate how how the United States is doing in these years when it comes to antitrust questions. If we try to put two regulatory ambitions up against each other, the classical approach to antitrust problems in the US has to really do with market performance, with efficiency standards and consumer welfare above all. And that is challenged or debated with a more progressive view, if you like, by the neo-Brandisian school of thought that has to do with market structure as a goal or an ambition in itself. If we try to infer paradigms from that, we could say the classical American antitrust has to do with post-Harvard empiricism, the ever-growing need for even more empirical economic standards, and that is debated by the neo-Brandisians with a more per se model of antitrust that is able to pursue competition as a goal in itself. Actual legal provisions, or the framework that is externalized from the paradigm, is very hard to catch. But one great example is the American Innovation and Choice Online Act that tried to incorporate neo-Brandisian agenda and failed. Of course, we can always say that the Supreme Court's jurisdiction is a good manifestation of classical approaches to antitrust questions. The public sentiment, I think there is a wide agreement among American scholars that American antitrust is under deterrent, and these scholars tend to, and they even question the justification of this under deterrence, that is the Arrowcross framework. So there is an agreement there, but the means of escaping this under deterrence is not yet defined. The European Union is a harder nut to crack and a harder ecosystem to be illustrated by the regulatory mind, simply because we Europeans are more keen on economic regulation under ordoliberal standards. And that is, I think that is manifested in the Europe Fit for the Digital Age program and all the regulatory aspects thereof. Just in a few quick sentences about the European regulatory mind, I think broadly speaking, and within the debate, we could say that classical antitrust approaches are debated by regulatory approaches, and by that I mean that the competing paradigms are approaching dominance cases, for instance, under scope of 102, and what the ECJ case law supplies us in this theoretic exercise that is assessing a dominance case. And from another aspect, we can approach a dominance case from the gatekeeper special regime doctrine that is employed by the DMA. And one great manifestation to this concurring to this debate between these two paradigms is that if the DMA would not have existed, maybe self-preferencing conduct, we could approach a self-preferencing conduct from a 102 perspective, and there is a theoretic scope overlap within the DMA and the TFEU in that sense. Well, externalizing that, the DMA is a great example of actual legal provisions sprouting from the gatekeeper special regime paradigm, and the public sentiment, interestingly enough, has to do with the fear for innovation due to regulatory overreach that is within the Europe Fit for the Digital Age. And I think it is very interesting how it is a flip side of the American public sentiment. Well, you might ask, what was the point of all this? Like, if someone, then you people are familiar with the landscape and the debate, I just tried to manifest how powerful as a tool regulatory mind can be, that in just a matter of minutes you can portray about how people, how professionals and laymen think about antitrust or any field of law problems in the current age. And the power of this tool is also great in delineating antitrust from regulation, in the sense that regulatory mind starts with an ambition, and this ambition and the paradigm that supports this ambition helps us when we navigate through the real hard questions of antitrust. For instance, what the pursued standards should be. Should consumer welfare or should be turned back to the Gilded Age? And it also helps us in navigating or avoiding demarcation problems. That is a Digital Markets Act antitrust? Should it be scrutinized under the lenses of antitrust? Is it breaking up with core legal principles by reversing the burden of proof, for instance? Regulatory mind takes the problems that the DMA is trying to solve and gives a special lens for us to scrutinize a piece of legislation, regulation. And by that, it helps us escape begging the question of antitrust, or begging the question of any field of law, in that sense that these are not traditional tools, so we should not employ them. And regulatory mind, and this is my last point, helps us in valuing the approaches that are more progressive in this sense. For instance, Lianos's approach, the toolkit, or whole government approach that he defines in his Exound paper. He says that antitrust should not suffice. It should not because antitrust cannot suffice, but it's a question that doesn't count. Antitrust should play a role in digital markets that is almost like what constitutional law plays. It should play a primordial role that only helps us alleviate tensions of goals, and doesn't support or doesn't inform our decision from a normative view. It only supplies a theoretic background and not an actual answer to our questions. And with that, I'd like to pass the floor to Professor Zsolt Zödi, who will give an insight on how the EU is doing in the case of user protection. Thank you.
Thank you very much. And after this very clear line of thought, I will confuse you with my, because I want to demonstrate this new paradigm, which is user protection, which is neither, I think, competition law nor anything else. This is a very sui generis platform regulatory tool. User protection. Two disclaimers. One, the first one is that I'm not a competition lawyer, and the other one is that I'm not evaluating this paradigm, this new paradigm. I just want to demonstrate that this I think this is the core, this is the new core paradigm of the EU, and try to somehow show you. So this is not an evaluation. Of course, I have an opinion, but I don't want to talk about it because the time is very limited. So this European paradigm can be best characterized by the paradigm of user protection. And in order to understand the user protection, we must start from the fact that many people, and especially Josef van Dijk, who is a very influential scholar in platform regulation and the theory of platforms, perceive the platform as a form of power, societal power. The platforms are not entities, not just enterprises, are not making economic activity, but they are entities where social power is accumulated. And this is done through datification, algorithmic management. And after that, because there are three phases, the datification is the first phase, algorithmic management is the second phase, and finally all the platforms are somehow monetizing this activity. In this paradigm, therefore, the central issue is not the market structure on the consumer's material well-being and these kind of classical questions of competition law, but the power of the platform over the users, the asymmetric relationship that manifests itself, the vulnerability of the user. It is very special because, first of all, it's impersonal. It is exercised by the platform through data and algorithms. This results in being an opaque and unverifiable with conventional means. Secondly, platform power is not only affecting the economic and material sphere of users, but affects their everyday life in a much more complex way. Their social relationships, mental relationships, and emotional life. All this results in the fact that platform power cannot be controlled with traditional antitrust tools. The solution will be the user protection, which is a special mixture of the already well-known consumer protection tools and investor protection solutions, but also borrows certain elements from constitutional law. Its general characteristics are the following. It is an ex-ante regulation. It relies very heavily on technology regulation and regulation by technology. So when you are regulating human activities by introducing technological solutions. An example of the former is the rule of the DSA, which prescribes that what the user interfaces should look like, and of the latter is when it details the specific technological implementations of notification and action mechanisms. User protection very heavily relies on the method of self and co-regulation, which is very popular in the European Union anywhere, because it very often only lays down the basic rules and principles, but leaves the details of the platforms of these rules to the platforms. User protection is formal and procedural in nature. It contrasts, so it differs from the consumer protection in this sense, because this works, the user protection, the consumer protection, with detailed lists of describing unfair practices, while the user protection in most cases defines only legal remedies, appeals procedural means. And finally, user protection protects not only the consumer, but also a wider group, for example, the small and medium-sized enterprises, as we can see in the platform to business regulation. The some elements of this regulation, specific elements from the DSA, but we can also mention the P2B regulation as well. Some of these are familiar from the consumer protection, and some from investor protection, and also corporate governance rules, such as the regulation that describe the minimum content or mandatory content of the terms of use. For example, that the users must be informed about the rules of moderation or advertisement placements. Similarly, a long rule from consumer protection is a requirement of comprehensibility of contracts. The transparency reports are very similar to the stock exchange disclosure rules that were introduced in the wake of previous stock market scandals. At the same time, new elements are those that, for example, protect the digital identity of the self, of the user, the prohibitions and expectations related to the unjustified deletion or suspension of the user accounts. User account is the central notion in this regulation. New elements are also those that protect users against manipulations, unfair influence, and unfair use of their data. A completely new paradigm is embodied by the rules that try to make the functioning of algorithms more transparent. So the transparency of algorithms is a central notion within this user protection toolkit. Finally, the rules that prescribe the explainability of decisions, mechanisms, and algorithms are coming basically from the constitutional law. So, in conclusion, is this competition law at all? No, it is not competition law. But the funny thing is, and I think that when we are talking about a field of law, like the competition law, we are not talking about particular tools or toolkits, that we are talking about the justifications behind a legal solution. Consumer welfare or a healthy structured market, or the preventing of market failures, or preserving the competitions, these are the classical justifications behind the competition law. User protection is different because it's partly relying on consumer welfare. It is talking about consumer welfare, but not consumer welfare, not only the consumer's welfare, or the individuals as a consumer, but the user as a human being, a kind of human being, as a complex entity, so to say. So the user of free services in several aspects, and not only economic, but other aspects as well. So I don't know the answer whether this is competition law at all, but I think these kind of solutions will stay with us for a long time. Thank you very much.
Thank you very much for the excellent presentations, and I'd like to only encourage those who are following this conference stream online. They are also able to ask questions on writing to the YouTube channel, and I'm also encouraging the audience being present to ask some questions. I'm highly looking forward for this session. We had this second thought to provoke some debate among the speakers. So we had some highly detailed approach how regulation does not take place, and also some other argument how regulatory ambition can evolve in a much more underpinned in a more coherent theoretical approach. So I'm seeing whether there is a question. Yes, please.
So you mentioned about so you mentioned about the growth, and you assume that everything that any actors in the competition field will play a fair. At the very least, you can assume that there is a certainty in growth model. So if we can agree with it, can you say that your assumption that a fine, economic fine or monetary fine, will be effective in that model?
Thank you. We not only have fines in competition law, so the toolkit is more complex, also depending on the jurisdictions. Like we see after 30 years, I think, again, a criminal case regarding Section 2 in the US, just before courts. Okay, but there is now a dominance, a monopolization case based on trying to send someone to jail. So the tools are more diverse than fines. But since fines can be quite high, at least in theory, so theoretically I would say 10% could be enough to sanction unlawful behavior. Because if you don't comply, then fines can be higher. Just look at the Microsoft case. Okay, substantial fine was much lower than the subsequent fine for not complying with the Commission decision. So for one particular behavior deemed to be unlawful, you can impose quite high fines and stop that behavior. If something else is done which is anti-competitive, then again you can impose another fine for that conduct. Again, these adding up, so if you do 3 different anti-competitive behaviors at the same time, that can be 30% of your annual turnover, right? 3 different cases. So you can add those together, and at the end, I'm not an economist, so just as a lawyer, I would say you could add those fines together at the end to get even large corporations to comply. And just as a side note, we always have the possibility to slice companies up at the end. So that's not frequent, but in principle we can do that.
So that means my question is now to Pál, whether purely traditional competition law tools would be effective enough, in your opinion, to address those challenges that are rising by the digital economy and the reflecting to the empirical evidence of some large technological company gaining such market power?
Depending on the problem you meet. So if it's democracy, then that's not a competition problem. So of course you can find someone for tying and assuming, well, this is because I think this will lead to an anti-democratic outcome at the end, like too much private power. But if you just look at competition issues, then yes, you can tackle them. We have more than 100 years of experience, and we set the limits. Something is anti-competitive or not, or if it's completely new, we can decide on the issue whether it should be anti-competitive or not. But if we say dominance is the line above which we should deal with these problems, then why should we go lower? We said for 30 years, 40 years, 10 years that below dominance you cannot act independently of the market. Market will regulate you. So we can set this line wherever we want, 30% market share with large entry barriers and so on and so forth. We can set this line, but below this line we say markets will regulate themselves. Above this line we can intervene if there is something contrary to the antitrust goals, whether it's consumer welfare, total welfare, consumer protection, whatever we choose as the end goal. But below the dominance threshold, that's my opinion, we should be very careful to intervene, or I should relearn economics.
Any other questions or remarks from the panel? What?
On which topic?
Yeah, my next question is to the all of the members of the panel, whether you support such an evolution when we can see that there are different aims of competition law. I could turn back to the presentation, to the last presentation. Can you assume such a scenario when user protection will become as one acknowledged aim of competition law, for instance, as a basis for, let's say, a regulatory ambition?
I start because I told at the beginning of my presentation that I don't want to evaluate this. Now I evaluate it. I'm not very happy about this. Mm-hmm. Because the toolkit, which is the user protection as a regulatory goal is using, is so much different from the competition laws toolkit. It is using constitutional law tools like the right to explanation and all these kind of things, which are so that can be the case that this will be one of the important justification of competition law, but then in this case competition law will not be it will change radically. It won't be the competition law we are now thinking about, or we think that this is the competition law. And to be honest, I don't like it very much because of several reasons. For example, that one of the instrument is that the technological regulation, that we are regulating technologies and we are using the technology to regulate the people. The by design movements are all about this. Everything which is about which is ending with by design are regulation by technology, that we are designing the technology in a way, technology and procedures, of course, in a way that these technologies will channel the human behavior into the desired direction. And I don't like this idea, to be honest. It will increase, I know, but I, as a kind of a traditional guy, I don't like this. I don't like to be channeled by technology.
I see. Turning back to, yes, please.
I think we are currently protecting end users. So consumers are the final users. So we do protect the end user. If your question is whether we should protect individual users, like from harm, then there can be a scenario. I like the concept. I'm not a fan of it, but I like the concept of relative market power. The Germans have that, and many other countries have that. So relative market power, that's, for example, within my mindset, that it can cause, well, a very broad analogy, but it can cause similar problems like we see in oligopolistic markets. Like no one is going to the competitors because there is someone who has relative market power regarding me. So I don't really switch between suppliers and so on and so forth. So we can have a similar problem, and that's a thing which could fit into competition law. But in general, I would stick to protecting consumers as the end users, but not individual consumers, but consumers as a general phenomenon.
Yes, just remaining on the established competition law, dealing with and reflecting using the established competition law phenomenon and definition. What is your opinion, or how should competition law address with its traditional toolkit the phenomenon that it's very hard to define the relevant market in the digital economy? In a recent merger control case, actually, the CMA was establishing that it does not possible to define the relevant market in a merger control case, and that was the Facebook Giphy actually, and went on saying that he will just analyze whether there is competition between the target and the company that wants to acquire. So my question is here, and that's open for all of you, in this highly dynamic market framework that characterizes the digital economy, are the traditional competition law toolkit and framework effective enough to handle these problems?
Well, just a few sentences. Thank you. Market definition, I think is just a reiteration of what Lina Khan says in the Amazon antitrust paradox, that with the Recalpman test for predatory pricing in the US set as it is set, we are unable to answer to these problems. But with traditional competition tools or antitrust tools, I think that it's sort of falling into the same pit that you're asking, that we might need novel theories of harm, but then again, those are novel theories of harm that are currently not encapsulated in traditional antitrust. But from a more technical point of view, I'd like to reflect on the role of price in antitrust analysis, and I think to be able to target business ecosystems with traditional antitrust rules, we have to find something that plays the role of the price as an informational bearer. So, for instance, data, we might have to find a way to commodify data and turn it into a quantitative something that is apt for quantitative analysis.
I'd like to reflect on the relevant market part. So relevant market, that's a legal concept, because they're from an economic perspective, well, it's a degree of substitution we have. Is this substitute a little bit more, totally, none at all? So somewhere we have to draw the line. Well, these are within the relevant market. And relevant market is used to think about the competition problem. So that's just a tool and not the end in itself. It's never been easy to define the relevant markets. Usually you do with my students, like, okay, Facebook, what is the relevant market? And of course it's difficult to come to a conclusion if you don't want to prejudge Facebook. I'm sure Facebook did something wrong, so I'm trying to find the relevant market where I can see the market power. So if I'm not going in with that mindset, just trying to define the relevant market, then we always see the problem. Well, it's difficult to see the actual market power regarding competition on whatever market. Of course, we have plenty of problems with Meta and Facebook, both from democracy to data protection and so on. That's just seeing the competition problem. We use the relevant market for that, and it's difficult to define. But I don't think that's a new thing that is difficult to. Fanta and milk. Well, I'm thirsty. Milk is solving my thirst better than Fanta. I might choose whichever. Are they on the same relevant market? Of course not, but still, there are to a certain degree substitutes. Yeah, sorry, too much.
Yeah, I agree with you. I think defining market is really hard, especially for a lawyer. And I don't think that there are clear lines. You cannot draw clear lines between the markets. So there's this speculation part. Even economic theory, although provides us some tools to do econometric analysis and by numbers, etc., still traditionally it's hard. And I think the discussions around the relevant market and digital industry is a little bit exaggerated. Well, it's hard everywhere. A little bit harder maybe within the digital markets, given that they are, they are serving to both sides of their platforms. And in Turkish experience, we have, as I mentioned in my presentation, there are like more than 20 cases, and they somehow define the market, and it looks nice. It looks okay.
So then it's my pleasure to thank you again for the very valuable contribution for this panel and the excellent presentation. And I'm also happy experience this lively debate followed by the presentation. And there are already some reference that we shall not remain thirsty. So that's the time for the lunch break. We invite you all to enjoy the served lunch, and after that we will continue our conference at 2 p.m. this afternoon. Thank you very much again.
So we deserve the lunch, right? We deserve the lunch.
Yes, so the lunch is served. Yes, that's right.
ladies and gentlemen, and welcome to all of you who returned to us after the lunch break. And I also greet all those guests who are joining us online. Well, my name is Judith Firnix. Okay, I can check that also the online presentation started. I'm here on behalf of the Competition Research Center of the Pázmány Péter Catholic University. As some of you could already meet me in the morning session. And it's a great pleasure for me both to participate in this panel and also to welcome you all to this event. Well, our panel this afternoon is going to be devoted to the enforcement issues arising in the digital markets. And we are in the privileged position that our speakers will offer us a broad insight to enforcement in light of the interdisciplinarity. First, there is a little change in the program structure. Márton Kocsis, partner at Czerhoff Hempel Budapest, will start. His topic is the intersections of competition law and consumer law. At this conference, of course, placed in a digital context. Márton has gained an extended experience as the head of the competition and compliance group at Czerhoff Hempel Budapest. Izabela Szaboszlai will be our second panelist. She is a member of the Competition Council of the Hungarian Competition Authority. She'll outline the consumer protection considerations and the consequences which can be drawn from the Hungarian Facebook case, which is a prominent case in the Hungarian practice. This important and relevant issue of enforcement will be closed by the presentation by Belle Beams from Radboud University, presenting the crossroads of regulatory fields, and she'll lead us to the issue of transdisciplinary cooperation between enforcers, while addressing the power represented by the big tech companies. Well, enforcement issues are always highly topical, so I spared the time for the panelists and I ask Márton to take the floor.
Thank you. And I should do it here. Okay. Good afternoon, ladies and gentlemen. Thank you very much, Judith, for the introduction, and thank you for the organizers to inviting me, and also for organizing this most interesting conference. I'm happy to be here. I asked Izabela to swap places with me because I think, well, some people find this spot right after lunch as a challenging position. I think it's rather a comfortable position because I can talk whatever I want. Most of you will probably still digesting, so if I'm too boring, then please feel free not to listen to me, and enjoy the rest of the lunch break within yourselves. Well, this is competition law or antitrust conference, right? So why the hell the lawyer is always want to show off, and why is he talking about a different field of law? Well, when I was invited by András to speak at today's conference, I suggested to him that we really should include something about consumer protection law. Why? Because not just because in Hungary there is a specific enforcement model when competition law and consumer protection law is mainly enforced by the same agency, the Hungarian Competition Authority, but because, and definitely not because a significant part of my work or my clients are asking for advice in consumer protection law cases, but mostly because I really believe that these two are genuinely connected. And some core competition lawyers might disagree with me in the audience, but I really believe that there are some similarities, and at least there are a couple of intersections that during such academic projects as a conference we really should talk about. And as a general disclaimer, I'm going to state really bluntly up front that I'm only here to propose some problems, to introduce some problems and to raise some issues, and I'm definitely not going to offer solutions or answers for those problems. I will leave it up for the discussion at the end of the panel. So why consumer protection? Why are we talking about that today as well? Well, mainly because it is quite evident that the ultimate goal and the objective of both antitrust or competition law and consumer protection is quite similar. And that is the economic welfare of the society. Although for the same objective, both consumer protection and competition law uses a different toolkit. Antitrust law or competition law mainly regulates businesses in terms of a B2B relation. For example, if you think about abuse of dominant cases, one firm is dominant vis-a-vis the other, or market. If we are talking about market power, the market power is used or exercised vis-a-vis another company, with less power. Consumer protection law, on the other hand, focuses on the B2C relations, so business to consumer relations, and instead of fair competition or level playing field on the market, it focuses on the undistorted decisional practice or transactional decision of the individual consumer. But ultimately, I think that both fields of law focuses on fair markets, fair competition, and the ultimate consumer welfare of society as a whole. But if we look at it from a different angle, then we might also see that advertisements are an important part of competition itself. So a good advertisement can bring you competitive advantage against your competitors. But what happens if you use an advertisement which is unfair? That would give you unfair advantage in competition. And this is the general idea behind the integrated enforcement model, which I will talk about in a minute, which is in place in Hungary, that the competition agencies should also enforce consumer protection rules to prevent a company from gaining unfair advantage in the competition. You should regulate how those companies are conducting their marketing practices. And this is the main intersection, I believe, between consumer protection law and competition law. Of course, most of you are already very well familiar with the European Competition Network, how competition law in the EU is regulated, that it is the exclusive competence of the European Union. Opposed to that, I think it is important to talk about a little bit about a quite similar cooperation within the EU, which is called the CPC, the Consumer Protection Enforcers' own private club, so to speak, the CPC, whereas consumer protection law is within the shared competence of the member states and the European Union. But the CPC hosts all the enforcement agencies as well from the member states who are dealing with consumer protection law cases. And it's an ever-evolving field of law, and consumer protection, I believe, with what have I seen in my 15 years of experience so far, is evolving much faster than competition law, because well, if we do not count the DMA and all the new developments in platforms and in the digital industry, competition law is quite stable and static because it's simply been around longer and it's already well known. However, opposed to that, consumer protection is still quite new and it's evolving in a rapid pace. And the new CPC regulation, which you can see on the slide, so I'm not going to bother with the numbers and the dates, is giving significant new powers to consumer protection agencies within the EU and sort of provides them with a minimum enforcement capability, quite similarly to the ECN Plus directive. And competition agencies were given the same toolkit to tackle anti-competitive behaviors. Now the EU really strives to enhance the powers of consumer protection agencies as well. Probably most of you are already familiar with the development that since last May, it is harmonized that in all member states, the consumer protection agencies must have the power to impose fines in the amount of 4% of the annual turnover of the companies who are infringing consumer protection law. And I'm quite disagreeing with this morning's speakers who are claiming that the fines are low. We can see in consumer protection that the highs are getting actually pretty much high. And this 4% annual turnover is quite significant in case of breaches of consumer protection law. Well, as 20 minutes is really not long enough to dive in to this topic in more detail, I would rather focus on some practical problems at the end of my presentation, so I will just jump through these slides, but it might be important to our foreign guests today, either in person or online, that how is it enforced in Hungary? And as you can see from the slides, we call it the integrated model. The integrated model's main characteristic is that the same agency enforces antitrust law and consumer protection law. And I'm already out of time, so I will really speed up. The Hungarian Competition Authority deals with advertisements which affects competition significantly. So those are mostly national-wide campaigns in television, all over the internet, or in national newspapers, whereas we have something called the government office, which deals with local cases, such as flyers in one city or local websites relevant to one county or to the other. What I wanted really to mention today is that we, as an international, we are a CEE-based law firm, so we have clients all over from the CEE region, Czech Republic, Slovakia, Bulgaria, Austria, Hungary. The main problem that we face during our day-to-day work is that opposed to competition law, consumer protection law is not fully harmonized, and the level of enforcement in different member states varies greatly. What do I mean under that? Well, the main issue and problem is that there are stricter agencies and stricter member states, and there are more lenient member states. And it's really difficult to explain to a client that if he or she can do something in Austria or in the Czech Republic, why is it not allowed to do it in Hungary? Because the same EU regulation applies in all those member states. However, the level of enforcement differs greatly. So it would be really great, I think, for European businesses to get some kind of standard enforcement levels. Well, as you can see from the slides, there are many future projects in the field of consumer protection law. I would only maybe mention the very recent Green Claims Directive, which is, just to refer back to what we heard today morning, that the EU is really looking forward to strengthen the environmental protection regulation and to somehow regulate firms on how to protect the environment. I also have my own doubts whether if it's of course it's a fair objective and I fully support it, might not be consumer protection law which is best fit to achieve such environmental goals. As I have 3 minutes probably to, I would really like to raise some issues and leave it up for the discussion for any solutions that you might think would be relevant concerning problems which involve both competition law and consumer protection law. Well, some of you might be aware that from last May we have the new price indication directive in the EU, and it was implemented into our national legal systems. Well, of course, when you organize a price reduction campaign, from now on you need to state the previous price or the prior price, which must be the lowest price applied in the last 30 days. But how can you do that if you are operating a franchise system and you have independent firms within your franchise network who price independently? Because it's a requirement under competition law that you cannot enforce the prices. In other words, you are not allowed to engage in a resale price maintenance scheme. If you are organizing central discounts in your franchise system, which is, I really believe that it is a good thing for consumers, they can get products cheaper. How will you ensure that you both comply with consumer protection and competition law rules? It seems quite impossible at this stage, so there should be some discussion about that. Maybe the other really interesting aspect, and I will finish up with that and we can discuss more during our question and answer round, is that especially in e-commerce, you have these must-have products. If you're operating a web shop, if you're operating an electronic themed web shop, you must have products from Apple and Sony, for example. Those firms very often organizes their own campaigns and own promotion schemes with already pre-written conditions and slogans and visual and everything. You as a web shop either choose not to implement the campaign of your supplier and then definitely lose consumers because they will go elsewhere when they can buy these must-have products. Or you can choose to implement these campaigns fully, because as an individual web shop you won't have any say in what is written in the campaign and in the terms and conditions. But what if there is something wrong from a consumer protection perspective with the campaign? According to consumer protection law, the trader will also be liable for the campaign figured out on the supplier level. So it might be a problem. On the other hand, from an antitrust perspective, can we assess these suppliers, these producers, as someone who is in a dominant position vis-a-vis these web shops? And I'm not talking about Amazon. I'm talking about local EU web shops. This is something which is also an intersection, I believe, of consumer protection and competition law, and the list goes on. As you can see it in the slides, I'm happy to answer questions if you have any, but I will pass on the opportunity to Isabella because my time is up, unfortunately. Thank you very much.
Thank you very much, Martin, for your thought-provoking presentation. And we are looking forward to Isabella's presentation on the Hungarian Facebook case.
Thank you very much. Hogy tudok kilépni, de hát nem jó az. Hol van? Ja. Ami Pázmányos című, és nem lesz itt. Igen, köszönjük.
I'm a really boomer. So it's funny that I'm going to speak about the Facebook case, being as a desperate boomer. Thank you very much for the invitation, the introduction, and for the help from Marton, because for me it's easier to speak the whole consumer protection situation with these helpful insights. I'm really embarrassed because of two reasons. I think my topic is quite simple, and the other reason is that all the presentation of the morning and even Marton's presentation is much more complex and much more abstract from the theoretical and academic point of view than mine. So let's start with short questions, with some short questions. Do you use social media? Yeah? Do you care about your privacy settings?
No.
No? Do you think Facebook is free?
Yes.
Depends. So, maybe your opinion will be changed a bit by the end of my presentation. First of all, I have to tell you that the Hungarian Facebook case is not a successful story. The courts annulled the decision of the Hungarian Competition Authority. But start with the goals of the relevant, some of the relevant regulation. All of the presentators mentioned directly or indirectly the goals and the aims of the relevant regulation or the enforcement. And even some of you mentioned that the goals of the competition is blurring. What is the real goal and why is it important, competition policy or the competition regulation? And I think it's not so blurring. I think everything is about, every regulation is about to have a balance in our society, in our economic. So I think the welfare we are looking for and the having the best situation, get to the Nash balance or any kind of optimal situation is our goal. And I think that a good tool to reach this balance is the consumer protection. Polly mentioned that if you have a hammer, which is a tool, don't use it because not everything is a nail. But I think that consumer protection is a hammer of Thor, so it can be used for nearly all the nails and other things as well. But what is the consumer protection is about? Actually, I'm not talking about the all consumer protection acquis because it's about a big thing. Just about the narrow portion of it, it's the unfair commercial practices regulation. The GVH is an administrative body. It means that it has a lot of rules to apply. For example, procedural legal rules. It's based on the Competition Act, and the material legal rules. It's the UCP Act, or in Hungarian abbreviation FTTV. UCPE is the implementation of the UCPD, the Unfair Commercial Practices Directive. What is it all about? I think if you want to have an abstraction, UCP is about to protect the well-balanced, well-informed transactional decision. And why is it important? Because all of us, not only consumers, but natural persons, want to have good decisions. In case of consumer protection, consumers, it's the transactional decision. So we always consider the value and the price of the products or any other situation. So we should know what paid, done, or undertaken in return exchange for a product. And that's why the question of this case was that, this Hungarian Facebook case, that is it fair to claim a service free if its use assumes a complex personal and other data pack from the users? I don't want to quote the decision. The decision was launched in December 2019, and one day before the launch of the decision, Margaret Vestager, Executive Vice President of the European Commission, have a speech, and she used the quoted this quoted bon mot that there is no such as free lunch, and save a few kroner today, we have accept an uncertain, unlimited risk for the future. I think that the Hungarian Facebook case was actually about this unlimited risk for the future as a transactional decision. What was the main considerations of the decision? We thought that that kind of claims that it's free and anyone can join, and free and always will be free claims distract the user's attention from the fact that they are indirectly paying for the use of its service in form of the transmission of their not only personal data. Not only is a very important factor, that because we know that a lot of people care about the personal data, but what about the other data which is not personal? For example, our activity in the social media. And not only their data don't care, they don't understand the extent of the data collected and all the consequences. We don't care about the risk, and we don't understand the risk. We are average consumers in a lot of sense. There is maybe you have heard about that, that there are things even from the European level, from the European Commission, that an average consumer of the digital era is quite sensitive and quite weak, because we don't know too much about the markets that are around us. And why is a superpower, in my understanding, the UCPA? Because it's platform neutral. I think it's a very important factor that UCP is a platform neutral. So the type of the commercial practice doesn't matter, and doesn't matter even the location of the business concerned, and the nature of the product is about to tackle. I think that my time is going quite fast, so I think I won't speak about the UCP, the notice, but I have to mention that, and I will suggest you to read it, because it's a very inspiring document, and it's important to mention that the Commission launched a notice, a guidance to the in the application of the UCPD, and the form, a Commission notice, is a much stricter and much maybe a stronger guidance than the guidance before, and it can help us to think about this whole topic. I don't want to detailedly show you or introduce you the legislative framework of the UCP. Perhaps a lot of the big part of the audience doesn't know too much about it, but especially because the antitrust interest. But it's quite easy, I think. There is a 3-level pyramid, and the legislation is the application of the system is going background. At first, we see whether the blacklist can be applied on, or the other articles, 6th, 7th, or 8th article of the UCPE, and then when none of them are applied, then we think about the general clause, which means that a commercial practice is unfair if it's contrary to the professional diligence and is able to distort the economic behavior of the average consumer. And it's important because to know about this framework, that the GVH used this kind of framework and stopped thinking about the conduct in question at the 2nd level, Article 6. Actually, the case was launched in different conducts, but the GVH on the the Competition Council decided to cease the proceeding with regard of the conducts falling under Article 3. It's the meaning the general clause, and stated that the Facebook's statement regarding freeness, it's free anymore and anyone can join, and it's free and always be free, infringed Article 6 of the UCPA. It means that it's stood on the second level of the enforcement pyramid. What factors were taken into consideration when evaluating this conduct of the Facebook? We watched the supply side market, the European Parliament proposal, the Omnibus, Martin mentioned the Omnibus directive, the new mindset or new insights of the proposal, the demand side characteristics. Yesterday my colleague Attila Kőhalmi is going to speak about privacy paradox and other kind of cognitive biases, and all these factors were taken into consideration in the Facebook case as well. And of course, the scope of the transactional decision was a very important factor in this case for us. And which was the consumer harm? It's always in competition cases, the harm theory is a very important factor, but it seems that even in consumer protection cases, the consumer harm is getting more and more important. So we thought that these all mistaken insights or mistaken consideration about the nature of the product and also about the nature of the transactional decision is a harm for the consumer, because this kind of communication stating free about something that is not without obligation can distract the awareness of the consumer and make consumers forget about the obligations they have undertaken in exchange for the service. And the other and not least factor was that all these privacy questions are very difficult to understand for the consumers. And I mentioned that this decision wasn't really very successful because Facebook challenged it successfully before the courts, and the decision was annulled. The principal contents of the Curia was, and maybe it's not a really absolute unsuccessfulness of the authority, because the principal contents opened a field for other thinking and forward thinking. That the Curia mentioned that the application of the article used the price of goods includes, in addition to financial compensation, any compensation that causes a disadvantage to the consumer, which disadvantage does not imminently follow from the nature of the goods. It's a very interesting point, because from that time the imminent characteristic of products are really questionable. A couple of lawyers are questioning this bon mot in a lot of cases in front of the GVH. Has a direct effect and is significant, meaning that this factor is able to influence the business decision. In the meantime, Italian competition authority was much more successful. They had the same decision, stating that claiming free in connection with the Facebook service is not legal, it's unfair. And their administrative courts, both the first instance court and the Supreme Court, upheld their decision. They stated that the personal data increases Facebook wealth, that's why user data is used for economic purposes. The data provided by the users become commercial. I'd like to mention you that in this case, in the Italian case, the Facebook used the different consideration in front of the jurisdiction. They classified the data as res extra commercium, in the sense that personal data is a fundamental right of the natural person and therefore cannot be sold or exchanged. This point wasn't in the Hungarian case, and even the Curia stated the opposite of this consideration. At the same time, Italian Administrative Supreme Court explained that GDPR is neither an absolute nor an exclusive law in terms of personal data. GDPR and consumer protection law are different areas of law, and their application is not mutually exclusive, which is quite good for the consumer protection point of view. And service providers should clearly inform the users about the any relevant information, and privacy processing or data processing is a relevant information in case of the free services. Another interesting consequence of the decision is that a lot of companies and lawyers use this decision in their uniformity complaint procedure. There are a couple of this new phenomena is quite often happens that lawyers reflect to the Facebook decision, and the Curia's 1 month on the Facebook decision. The quoted statements are not in the, of course, not in the Facebook case, but in other case. But it's very important that Curia highlighted the acceptance of general terms and conditions in Czech laws cannot make incomplete communication legal, which is very important. One of the most important things in the digital markets for the consumer protection cases and consumer protection thinking. If we accept legal terms, it doesn't mean that we know the content of this information. I think I have a couple of notes what to want to say. I think I'm going home with a big package, and I hope I can give you some small package to think widely, and not only with the competition point of view and data privacy policy in another enforcement point of view, but from a consumer protection point of view as well. And I hope I will have a lot of questions from you.
Thank you very much, Isabella.
Can I start?
Of course.
Yeah. Okay. Well, first of all, big thanks for to the organization for having me here. I'm really happy to be able to share my findings on the intersection of competition law, data protection law, the DMA, and I'll also take into account the Data Act and the Data Governance Act. So just as the other panelists, I'll take a broader perspective and go a bit beyond the field of traditional competition law. In my presentation, I will focus on public enforcement of personal data markets. So I'll go into the enforcement by public authorities responsible for different fields of law, and I'll make an analysis in light of the coherence principle. In order to do this, I will go briefly into the relevant legal framework and the blurring boundaries. I'll address some of the most important trends and challenges, look at the responsible authorities, the existing cooperation and coordination mechanisms, and I'll conclude with an analysis. So first of all, the legal framework that I'll be discussing today. As most of you are probably aware, and as has been highlighting today already, there are a number of regulations, instruments, and legal area in place that regulates the position, the powerful position of big technological undertakings. We have more traditional or older fields of law as competition law and data protection law, but also recently a number of new initiatives have been enrolled, both at the European and at the national level. Since there's so much going on, it is impossible within the time frame of this presentation to address all regulatory developments, and therefore I chose to limit myself to the DMA, the Data Act, and the Data Governance Act. The presumption or first hypothesis of my presentation is that the boundaries between the legal branches that I just mentioned are becoming increasingly blurred. This means that those legal fields or those legal instruments which have traditionally been applied in isolation and which have their own objectives, substantive frameworks and institutional frameworks at the fringes get closer to each other or arguably even overlap. I think there are three main reasons or trends that foster or spur this overlap or this process towards blurring boundaries. First of all, we're dealing with a new economic reality on personal data markets. As also been addressed by Isabella, online platforms thrive by business models that center around the collection of personal data. If you use Facebook, for example, you're not paying a monetary fee. However, you do transfer your data to Facebook. Facebook in turn gets to monetize this personal data because advertisers on the other side of the platform are willing to pay a monetary fee to reach a certain targeted audience. Facebook is capable to offer access to these highly targeted groups because we, as consumer, transfer our personal data. In this light, we see that the availability of this data or the access to this data to an increasing extent becomes a competitive parameter. A next question is whether it's a price or a currency. It's a hot debate in competition law, something that I won't go into, but I think for now it's at least fair to state that it gets a competitive value. This has also been acknowledged by the European Commission. They, in their recent new documents on the market definition, for example, explicitly mentioned the level of data protection and privacy as an element of quality. So here we see that in these traditional competitive parameters, data and also personal data becomes of increasing importance. And therefore, or as a result of this, the areas of competition law, which aims to facilitate competition in order to enhance consumer welfare, and data protection law increasingly collide. Then the second two trends, which could be seen as a response or a reaction to this first trend, further foster this process of blurring. Because first of all, we see, and the Facebook Bundeskartellamt is the clearest example in this regard, that enforcers now tend to go beyond the traditional boundaries of their own legal field. In the Facebook Bundeskartellamt, the German competition authority, took into account data protection considerations in order to make a competition law assessment. So these enforcers are also confronted with this changing economic reality, and in a response to this, they tweak their assessment or their analysis by taking on board considerations of a field of law that it traditionally goes beyond the boundaries of their responsibility. This further results in blurring boundaries. Then lastly, we see a myriad of regulatory developments. So both the European legislator, but also member states legislator adopts numerous initiatives. And also those initiatives, to a further or lesser extent, overlap with either data protection law or competition law. It's already been highlighted today, so I won't go into detail, but the DMA, for example, shows some very clear similarities with the area of competition law. It's something different, but the objectives, substantive provisions, and even the institutional framework are highly similar. And these three trends together result in this blurring or more complicated landscape. This process of blurring results in several challenges. Those challenges are both substantive and institutional in nature. Important substantive questions are: to what extent should one field of law leave room for considerations of another field of law? This is a question that is highly debated in light of this Facebook Bundeskartellamt case. The main question there is then, is competition law about privacy, or more normatively, should competition law be about privacy? A second type of challenges that arise here are more institutional in nature. The question there, to put it very basically, is who should do what? In order to bring it back to the same example, should a competition law authority deal with data protection considerations? This who should do what question will be the focus of my presentation today, and is also the focus of my own PhD research. Those institutional questions can be distilled back towards a very simple question with probably a highly complicated answer, namely, to what extent is the current institutional framework or the institutional frameworks of these different legal branches sufficiently coherent? And in order to assess this coherence, it is important to take into account cooperation and coordination mechanisms, because we do see that we have these blurring boundaries, and this runs a risk of incoherent application of different laws, which may result in a lack of uniformity. However, if we have sufficient mechanisms in place to deal with these overlaps, this can be prevented in practice, and under such circumstances, the increasing overlap would not necessarily be a bad thing. As I said before, I won't go into the substantive questions, but I'll only take the more institutional perspective today. In order to take the institutional perspective, it is of course important which players are at this stage. For competition law, it's mainly the European Commission and national competition authorities. Then data protection law, contrary to competition law, is enforced much more decentralized. That means that in the enforcement of data protection law, the different national data protection authorities are in the lead. The European Data Protection Board plays a certain role in cross-border infringement. We'll get to that in a bit. Then for the DMA, it will also be more centralized, so we have the Commission and the national competition authorities in a supporting role. And this is where it gets more complicated even institutionally, for the Data Act and the Data Governance Act, we don't know. Because it's up to the member states to appoint a designator supervisor for those two instruments. And the text explicitly states that it can be either a new authority, a competition authority, or a data protection authority. And as it seems now, we will indeed be confronted with the situation in which this Data Act and this Data Governance Act in some countries are enforced by data protection authorities, but in other countries by either telecom regulators, competition law regulators, or something entirely novel. And that, of course, complicates the institutional further complicates the institutional picture. and this increases the need for transdisciplinary cooperation. Because in terms of cooperation, we have very well-established mechanisms. Those well-established mechanisms mostly entail intradisciplinary cooperation, so they focus on cooperation between different authorities responsible for the enforcement of the same legal branch. Regulation 1/2003 and the European Competition Network are a clear example in this regard, and this mechanism is presumed to function rather well. In data protection law, we also have a consistency mechanism in which, in cases of cross-border processing, a lead supervisory authority is appointed. This system arguably functions less well because in many cases the Irish authority takes the lead, and there seems to be somewhat of a deadlock in Ireland. Then there is increasing attention for transdisciplinary cooperation, so that would be cooperation, as you could see on the picture on the right, cooperation between authorities responsible for different legal branches. This type of cooperation is far less developed, but over the past few years or decades got some academic attention, and now we slowly see a shift towards much more attention also by the EU legislator. Let me give you some examples in this regard. On the Competition Law, Data Protection Law Acts, the need for cooperation has been stressed by several academics and also by the European Data Protection Board. This call for cooperation has a good few years ago been endorsed by the European Parliament, and in a response to this, a digital clearinghouse was established. This was an informal network in which data protection and competition authorities could cooperate. It hosted about 4 meetings, but right now it does no longer seem active. There's no formal correspondence on this, but apparently it's a lack of funding issue. Transdisciplinary cooperation is more elaborate in the competition law DMA relationship. The Commission is very clear, the DMA is not a competition law instrument, and therefore this would entail transdisciplinary cooperation as well. In the DMA, very explicit provisions for cooperation are established on the basis of which national competition authorities can support the Commission in the DMA enforcement. Also, it's clarified that they will cooperate in the context of the European Competition Network, which is actually quite weird because the DMA is not a competition law instrument, but still we're using our competition law forum to establish cooperation between the responsible authorities. This issue of transdisciplinary cooperation is also very clearly taken into account in the Data Act and the Data Governance Act, and in my view this shows that it's something which relevance has also been endorsed by the European legislator at this point. The Data Act and the Data Governance Act both expressly state that the authorities in different member states should cooperate. And this will very likely be a transdisciplinary cooperation because, like I explained before, in some countries competition law authorities may be responsible, whereas in other member states the data protection authorities may take the lead. Then there are some provisions on the Data Act, Data Governance Act enforcer and the cooperation with competition authorities, and it is, for example, stressed that information should be exchanged between these authorities. The means by which this will be done are not entirely clear at this point. It's not only a trend at the European level, but it's also something we see in some member states, at least in the Netherlands, because there the importance and need for transdisciplinary cooperation has been endorsed by the president of the competition authority, Martijn Snoep. he explicitly stressed that the cooperation with data protection authorities, but also sector-specific regulators, should be reinforced. And on top of this, in the Netherlands, we have the Samenwerkingsplatform Digitale Toezichthouders, which is a platform in which NCA's, data protection authorities, financial supervisors, and the media supervisors can cooperate or coordinate their actions. So to sum it up, transdisciplinary cooperation is something novel. It's not nearly as established as the intradisciplinary cooperation, but it's something that gains increasing importance. Of course, for transdisciplinary cooperation, we're faced with some challenges we didn't really have before. First of all, those different fields of law, although there are some common denominators or shared objectives, have different objectives, and the application of these fields may point in a different direction. In some instances, the areas of law may even clash. And this, of course, can be an obstacle for effective cooperation in those fields. On top of this, independence issues may arise, especially because the requirement of independence seem to be more strictly interpreted in a data protection law context than it is in a competition law context. It is then questionable whether, from the perspective of a data protection authority, a very intense cooperation with a national competition authority or with the European Commission is desirable in light of this stricter independence principle. Then my two final arguments, and those are more closely related to efficiency considerations. First of all, those initiatives are, at least at this point, very informal, and the binding powers are very limited. That can have an effect on the effectiveness of such fora. And on top of this, we see, for example, when it comes to the digital clearinghouse, that the financial means are very limited. A lack of financial means can have a negative effect on the effectiveness of such fora. This lack of means is not something that's only apparent at the fora level, but also the individual authorities are struggling from a lack of resources, especially the budgets of the data protection authorities are a matter of concern. And it is therefore questionable whether those authorities, on top of the workload that they're already having in their own member state, can be asked to participate in very time-intensive and complex transdisciplinary coordination. I think those are some of the most important challenges in this regard, and I'm looking forward to your questions and the discussion.
Thank you very much for this insightful presentation, Belle. And we decided to open the floor to the questions. First, I'd like to invite the audience to come up with questions. Yes, please, there.
Just a remark to Belle that this data, the instruments that are regulating the data, it has a predecessor, the PSI directive, which is from 2003, you might know that. And there was a network which was very interesting. It functioned for more than 10 years, and I was a member of it, the EPSI+ network, which was monitoring the implementation and the use of the reuse of public data, so the predecessor of the Open Data Directive. And I think that the website is archived somehow, all the materials. It was a very rich, very lively group consisting of public institutions also, but the business users, business reusers of the data, plus the governments. And I'm just recommending you to see that network. It was very interesting. It was not an official organization, but a network of business users and mixed users, and it was. I think it was a very useful tool for monitoring that directive, the functioning of that directive. Thank you.
Thank you for your remarks. Oh, Pál has a question there. Thank you very much.
Thank you. My question would be: do you see a danger to the panel? So anyone from the panel, do you see a danger that if we put all these responsibilities on one competition authority or one authority, then there might be under-enforcement of one or more areas for which the authority is responsible? Like having two, that's also might lead to problems, but having all these responsibilities, so do you see a danger in that?
Well,
is that
yes. On the other hand, we would avoid the nebis-needem question and forum shopping possibilities as well. But yeah, I think it's my opinion. It's my opinion that it's very dangerous. Especially because the transdisciplinary cooperation is quite okay, I think. So it's a must, actually. But as I mentioned, the nebis-needem principle and the forum shopping possibilities would be avoided.
And maybe just one remark that we, from the practice, already seeing this in Hungary. It is clearly visible that the Hungarian authority focuses more on consumer protection than on classical antitrust. And for me, as a competition lawyer by origin, it's a painful thing to see. I'm not saying that the one is more important than the other, but this is definitely a concern. However, I think that the rise in the integrated model is inevitable, so it will happen. But this is something that the agencies should be careful about, I think, yes.
Yeah, I think this integration versus separation debate has been very present in terms of cooperation between consumer competition and sector-specific regulators. In the Netherlands, we also have this more integrated approach. I think when it comes to data protection law, such integration would be much more difficult. First of all, because we have this stricter independence requirement, but also if we look at it more fundamentally, data protection law is also enforced vis-à-vis governments. So it's not only a control of those big platforms, it also protects citizens from interference by the government, which means that other authorities have to comply with data protection law as well. And therefore, although it may be highly efficient when it comes to platform regulation or the governance of platform from a fundamental perspective, which is so present in data protection and privacy law, I don't think this institutional solution would be as workable for that relationship.
Andrés?
Thank you very much for the presentations. I do have a remark and also a question. Joining mainly to the presentation by Bella, I have in my mind the memory that this kind of approach, more integrated approach, is already claimed for a long time from different players of the enforcement side. The European Data Protection Supervisor, in its opinion back in 2018, if I'm not mistaken, was calling to put more attention on the interplay between competition law, consumer protection law, and data protection as a necessary answer for all those programs and market anomalies that we were investigated much into the detail in the first two panels as well this morning. And also within the competition law community, there is an international cooperation network, the ICN, which is started this intersection project again, claiming the very same approach. And not long ago in a conference, and a high official from the European Commission was also claiming that since those platforms are raising so complex issues, some kind of similar approach from an enforcement side should be introduced. Now, my question basically for all of you, if I understand correctly, there is an openness from the side of the Dutch authority, at least the competition authority, to work together with other agencies. But do you see that in the Hungarian field as well, between the different enforcers? There are any openness to cooperate together with the issues in this changing field of digital economy? Thank you.
And if you allow me to add an aspect to András' remark and question, well, there is a significant number of cases where it's not quite obvious whether the relevant conduct can be optimally dealt with consumer protection, antitrust, data law, or the newly emerging platform law. In this cooperation in the Hungarian context, can you see any optimal best scenario, some best scenario to assess where the given case can be dealt with? So I suppose that's another side of your question, András, and it can be also relevant and intriguing for all the authorities and the market players as well.
I think that from the consumer or any other natural person point of view, it makes no difference who solves the problem. But as it happened in the Facebook case, it's not really indifferent whether the proper regulation and the competent authority is chosen. So I think it's not a question of openness or the possibility to cooperate. It's a must.
Can I answer with a funny story? There's been a law in Hungary since 2001, apparently. I was not even aware that it exists because nobody enforced it. The law says that in an advertisement, you must always use only Hungarian language. There are some exceptions. For example, if a trademark is in a foreign language, then you can use it. But other than that, it always must be, the slogan, everything must be also at least in the same size and in the same visual as in the foreign language. And it's been around for 25 years almost, nobody enforced this. Now, for some reason, politicians found this legislation and started big campaigns nationwide that they will strongly enforce it to protect our precious mother tongue. We had a client with physical stores all across the country. Of course, during the discount season this winter, in each store the slogan was sale, sale, sale. I think everybody knows what this means, but it was written only in English. And as I mentioned in my presentation, local advertisements are dealt with by the government offices. And in Hungary, the government offices are not a centralized agency. They have 19 different branches in the different counties of the entire country. Now, what happened is that we prepared the same submissions for each government office, which came to the store and investigated and found that you are infringing this law from 2001. So we put forward the same defense in each and every case. And bottom line of the story, that not even between agencies, but between the same agency, different branches, there are no communication whatsoever. One store got fined, one store got off with a warning. the different branches of the government office did not talk to one another. Same client again. So I would strongly encourage various agencies, and I'm pretty sure that it's not because of the lack of trying, but for whatever reasons, to talk more to one another. That would be really helpful.
Yeah, I think in general the enforcement framework and the institutional framework, which would focus more on who enforces, is really important and is something that is often not taken into account sufficiently, both in probably academia but also by the EU legislator, because what is really a really striking example in this regard, that in the initial proposal of the DMA, so the initial commission proposal, the NCAs were not mentioned whatsoever. So their position wasn't taken into account at all, whereas they're enforcing similar issues, and whereas some DMA obligations are even drafted in light or inspired by national antitrust cases, such as this Facebook Bundeskartellamt case. In the final version of the DMA, there are some mechanisms in place, but in general, those institutional arrangements seem to be often overlooked. And then we end up with a myriad of different new legal instruments. In the first place, the interrelationship between those legal instruments is unclear to start with. And then when you look at it institutionally, so the who should do what question, it becomes even more opaque because it seems like different regulators are popping up at various levels, which means that we end up in two highly complicated relationships, because at the one hand we see horizontally, so for example in a competition law context, that different notions or different elements of economic reality are interpreted differently. If we look at the question, is Facebook free, for example, this now seems to be interpreted differently in Italy than it is in Hungary, which is a problem in itself, but this question will also be phrased in terms of a data protection law case and also in terms of a competition law case. And there we see now that the European Commission seems to be taking a certain approach, but there are no, or I would say not enough, sufficiently efficient or well-functioning mechanisms to put forward a streamlined approach here, and that of course runs a huge risk of either under or over enforcement.
Thank you very much. Any further questions may have? There, please.
So, thank you. First of all, my question will be towards the price discount representation, and I must admit that my question must come from lack of knowledge, because I couldn't go into details of your regulation. But as far as I remember, now we have to present the price that was the lowest in the last 30 days, and in terms of new products, it's the last 15 days. But what if I have a new product and I say that, okay, this particular product will be 100 euros from 15 days now on, but now if you buy it, it's 20% less. Then I have to demonstrate 30 days later, 50 days later, that I actually sold it 20% less 30 days earlier, or popular. Shall I write something on my webshop that now the price is truly 100 as I promised, and I didn't opportunity to mistake?
But first of all, you have to be sure that write it in Hungarian. Well, I suppose that your question reflects that the devil is really in the details. So, Martin, as a practitioner, maybe you can most efficiently answer the question.
Yeah. First of all, call a lawyer. That's for sure. Before doing that, well, if you take the new rules strictly, and I'm also looking at the lady on my left, then you are not allowed to do that. If you are introducing a new product to the market and it hasn't been around for 15 days already, you are not allowed to advertise a discount. However, I think this is my private opinion, so it's not shouldn't be considered as legal advice, but but I think that you are allowed to say that this is my price for this new product. It will be higher within 20 days, 30 days or so. And if you follow what is being promised and it will eventually really go up the price, then I think you are in the clear with this. But you are not allowed to call it a discount. You can say that this is the price now, this will be the price later on. And then this practice will be assessed under UCP rules and not under Omnibus rules.
I agree with Marton, but it's not an advocacy, just my opinion that it's not a real price reduction communication, it's just a price communication, and if it's not okay, it can't be just justified after the communication, after the price increase, then it might fall under the regulation, UCPD regulation. So you have to prove
later on that the prices are actually went higher.
And I think that if there is quite a big exaggeration in the statement, it should be infringement.
Sorry, it's my sorrowful obligation to thank you all the questions and close this fervent debate, which I encourage you to go on with in the coffee break. And thank you for all your participation, attention, and last but not least to our panelists. Thank you very much.
Thank you.
We'll go on with our program in 10 minutes.
your talk. So we are very happy to introduce Professor Spencer Waller, former Chief Advisor of the Federal Trade Commission Chair, now a professional at the Loyola University, Chicago. And we are very pleased to give the virtual floor to Spencer and listen to her to the speak of Professor.
Well, thank you very much. I hope you can all hear and see me, and I'm delighted to be here. Thanks to the organizers of the conference for having me as part of your program, and I'm sorry that I can't be with you in person today. My remarks are on the topic of what I'm calling bespoke antitrust. This is a paper and a topic that I have explored with Professor Harry First, who is my co-author and oftentimes a co-presenter. And also, before I begin, this paper is dedicated to the memory of a professor who you may not be as familiar with, a brilliant professor and former practitioner at the highest levels named Thomas Horton, who passed away unexpectedly late last year. And this paper will be published in a special symposium issue of the South Dakota Law Review. And Professor Horton had an extraordinarily funny and sophisticated and interesting way at looking at questions of antitrust law, often drawing on all kinds of things from social science. And if you ever have the chance to read his work or learn more about him, I highly recommend it. Now, our topic today, and I'll be sharing some slides with you in a moment, is a lighthearted look at a serious topic. This paper looks at to what extent should antitrust competition law be, in general, a body of rules of general applicability versus some highly custom-made rules for specific situations and very individualized problems. And so when you think about in the law in the United States, the cases are full of references to tailoring and customizing. And this made Professor First and I think about the law of fashion. And so we're going to be using the law of bespoke or customized fashion as just a way to think about how competition law should be, again, kind of tailored for the specific situation where you have highly beautiful, but kind of almost original, never to be worn again or used again kind of situations, or rules of general applicability that you can use day in, day out as needed. So let me start the slides. And so if we're going to use the analogy of fashion to provide some insight into obviously serious topics of competition law, there are two extremes. One is the jeans, the t-shirts, the things that we all have in our closet that we wear for everyday occasions. And that's on the left of the slide. And then on the right are the beautiful, highly individualized haute couture fashions that go on at the New York Fashion Week and Paris Fashion Week, and you can see in the fancy brand name boutiques all over the world. And so in terms of law, there's a similar phenomenon, particularly in competition law. The laws in the United States, and I'll be speaking primarily but not exclusively about US antitrust law today. From 1890 on, the Sherman Act was designed to be a uniform one-size-fits-all. You would never have just one piece of clothing in your closet, and the US antitrust laws from the Sherman Act and the Clayton Act and the FTC Act gave 3 or 4 main pieces of attire to address the problems in our field. All of you are familiar in general with Section 1 of the Sherman Act that talks about every every contract and restraint of trade is declared to be illegal. Section 2 talks about every person, artificial or human, who shall monopolize shall be deemed guilty. And Section 7 of the Clayton Act, which was added later, but again, no corporation shall acquire another corporation where the effect may be to substantially lessen competition. So you have 3, and then the Federal Trade Commission, somewhat more elastic, somewhat more tailored, was also introduced in 1914 that prohibits unfair methods of competition and unfair and deceptive acts and practices, giving it the 2 main weapons in antitrust and consumer protection. So if these are the basic garments in the closet of US antitrust law, the customizing, the bespoke, the custom tailoring began very early. And the problem is, in many cases, there's only one move. The courts have, particularly over the last 40 years, moved from per se to rule of reason. So it's always one move in the tailoring, and it's always to the right. And this is sorry, as I mentioned, we have some jokes in these slides, although we're talking about a serious topic. This is from the movie Zoolander, where the Ben Stiller plays a famous model who can only do one turn where his head goes to the right versus the left. For antitrust, the tailoring begins early. In 1918, Justice Brandeis gives the traditional definition for the rule of reason, which is by definition a case-by-case rule that is tailored to what's going on in that industry. It's not a categorical prohibition like a per se rule or a by object. It simply says you have to know quite a bit about the particular situation that is peculiar to the business to which the restraint is applied. Let me suggest to you that if you do all these things that Justice Brandeis says, you have essentially very little rule of law and very much a case-by-case application where everything depends on the history of the industry, the nature of the industry, the facts that are peculiar to the business, the evil that's supposed to exist, the reason for adopting a particular remedy, the purpose in the end, all these relevant factors. And many, many people have been critical of the rule of reason because it really means that everything is relevant if you take this definition and nothing is determinative. Now, whether you've had a per se or rule of reason approach, more and more bespoke tailoring has gone on in US antitrust law. So, for example, a relatively recent Supreme Court case dealt with certain restrictions that colleges and universities put on the compensation of amateur student athletes. In essence, universities were allowed to give the cost of attendance a full tuition scholarship and a small range of other payments. And the district court in the NCAA case found that these rules were anti-competitive, but the district court got out its tailoring shears and designed a less restrictive alternative for the NCAA to follow that would be legal. And it came very, very specific things that had to do with the amount of extra graduation awards and academic awards and cash incentives, and simply more or less allowed anything that was education-related benefits without limit and certain other things where there were limits. It may be right, it may be wrong, but the Supreme Court more or less adopted that the old system was illegal. The new system with these limitations was okay. And you had an extremely finely tailored solution to a Section 1 that on its face prohibits every restraint of trade. The bespoke trend continues in Section 2 as well. The classic case of the United States versus Alcoa more or less applied the finding of illegality to a firm that had monopolized a market and limited and virtually eliminated all defenses. By the time you get about 60 years later to Microsoft, you have a finely grained analysis of something like 18 different acts and practices that Microsoft has that are judged one by one. And more importantly, the remedies are applied one by one to prohibit those things that were found to be specifically illegal, but not other things. And in fact, we can talk about this a little bit later, in the area of tying law, to give you an idea of how bespoke Microsoft is, which is a decision of the DC Circuit, not the Supreme Court, but a very, in general, well-respected opinion. In the area of tying, where the Supreme Court applies still a quasi per se rule. The Microsoft court, a lower court, said, well, that's fine, but the Supreme Court has never heard a tying case involving computer operating systems like we have before us. And so we accept their law, but create a new legal test for when tying is and is not legal that applies only to computer operating systems on PC computers operating Intel chips. It cannot get more specific, more bespoke, more custom, more tailored than that. The same thing basically goes on in the merger area. The Supreme Court created a series of presumptions of illegality, where a firm created a market with an undue share, and it allowed very few defenses. And in the Philadelphia National Bank case itself, did not grant any of those defenses and really gave them very little consideration. Fast forward to the present, and again, the courts are saying, well, these rules may be fine for commodities like milk, but telecommunications systems in the Deutsche Telekom case are very complex, and you need very specific merger rules and remedies because competition in the market for, say, cinder blocks should not be assessed by the same rules and practices prevalent in the market for computers. And this is not just in the courts. In the United States and elsewhere, you see the carving out of special rules designed to cover either special individual practices that will be treated differently than other types of practices in the same area, or industries, or in some cases, individuals who are literally exempt or subject to different regimes to determine whether they are liable or not liable for competition law violations. And so all manner of legislation, and I can give you just a handful of examples in the United States, and obviously coming from Congress, this is probably the place where you would expect in a democratic society to have specialized rules. Congress is free to adopt any rule they want. They adopted the Sherman Act. They can adopt later acts like the Clayton Act and the FTC Act. They can get into micromanaging, super detailed tailoring if they think there's a unique situation that deserves different rules. So for example, going back all the way to the 1920s, Congress was very concerned that ranchers and farmers were not getting a good deal. Were being abused by industrial firms with their buying power to the detriment of farmers, ranchers, chicken growers, producers of meat and poultry, that sort of thing. And so Congress took two different paths. One path for farmers was to allow them to form cooperatives that would be immune from the antitrust laws, and so sort of sell collectively under certain circumstances. At the same time, the Packer and Stockyards Act created stronger antitrust laws that prevented powerful meat processors from discriminating in any way, and had sort of a more expansive view of market power and violations of that sort. And I can go on and on, but many of these bills are in the nature of exemptions and immunities. As some of you know, the sport of Major League Baseball has a partial antitrust immunity as a result of legislation in the 1990s. There's a probably very useful immunity that allows pharmaceutical companies to do certain things together to jointly produce vaccines, flu vaccines, on an annual basis that address the current strain of flu and coming out of the pandemic. For COVID, we all understand that is a very important thing. But again, they operate under a different regime, and probably the most custom-tailored immunity coming out of the legislature in the United States is one that happened a few years ago, where there is a system where medical students who are graduating are matched with a hospital for their first year of residency, where they learn more about their specialties and work under the direction of physicians for both teaching and seeing patients. There was a serious issue in litigation whether this violated Section 1 of the Sherman Act, and while the case was pending, the defendants successfully lobbied Congress to add an antitrust exemption in an otherwise utterly unrelated bill that had to do with pension law and tax stuff to immunize this particular medical match program so that it can continue. And if you're talking about custom tailoring, things that are highly individualized because there's a judgment that the circumstances call for this. One of the other areas to think about are consent decrees, which are settlement agreements in the United States between one of the public agencies, FTC or the DOJ, where the defendants do not admit liability other than the jurisdiction of the agency and agree to settle some dispute either before the case is formally filed, but it's then sent to court for court approval and supervision, or in the middle of litigation. And just this past week, the Department of Justice was litigating a merger in the hardware industry involving locks for doors, particularly for new home and apartment construction. And, pardon me. The Department of Justice had obviously negotiated with the defendants before the case was filed. They were not able to reach agreement. The Department of Justice sued. The defendants kept making different offers about what they would divest and how they would divest and timing and the like. And finally, in the middle of the trial, they reached a consent decree that was satisfactory to each party, where literally the number of brands and who they'd be divested to, and the support by way of employees and know-how and assets and relationships between the newly spun off assets and the remaining assets in the companies at merging. These are all laid out in the consent decree that will eventually be reviewed by the court as whether or not it's in the public interest and satisfying all the requirements of the antitrust law. Let me just suggest to you that this kind of consent decree, the consent decree from Microsoft, and any potential consent decrees that are reached with any of the high-tech platform companies that are either in litigation or under investigation, will be highly tailored and highly customized, and will not give a great deal of guidance to other defendants as to what does and doesn't violate the law, because the circumstances are so very specific. So both consent decrees and remedies, the case law in the United States and just the practice in the real world, is that you can, of course, counsel by reading the detailed consent decrees and reading between the lines, but it's very, very hard to then advise another defendant who's in a different industry or in different circumstances how that would or wouldn't apply to their line of work. Similarly, in the United States, there is the potential for business review letters and advisory opinions where the agencies review conduct that has not yet been implemented and provide an opinion whether they would or would not be likely to challenge based on the facts as stated by the businesses. In addition, the FTC in particular, and occasionally the Department of Justice, issue reports of different kinds and closing statements where they explain why they did not bring a particular case. There's no legal obligation to do so. But there's often, in a case that is a close call, where the agencies will provide some explanatory statements. They're very helpful, but again, they suggest how specific, how tailored everything has become. And then finally, this is the case more outside the United States than in. Competition agencies have the power to do various kinds of market studies and market inquiries. And in many cases, if they find a problem, they will devise a highly customized solution. One of the best examples you may remember is in the United Kingdom. Some years ago, there was a market study, market inquiry involving the grocery industry. And what eventually happened was the creation of a code of fair conduct that applied to the grocery industry and no other, to settle claims as between branded manufacturers and house brands of the same kinds of foods as sold in these supermarkets that had great power if you were anywhere in England, Scotland, or Wales. So why do we care? Well, in antitrust and in fashion, the tailoring, the bespoke can go so far. There are what we would jokingly refer to as fashion felonies, where someone has spent a huge amount of time and expense creating something that just really isn't appropriate. And if you remember, if you follow any of these celebrities, on the left is Lady Gaga wearing what I think she described as a meat dress. And on the right is Sarah Jessica Parker, Bjork in her swan dress, and Cher in some kind of outfit that she wore to some awards ceremony. And on the other end of the spectrum, sometimes you wish people had put a little more thought, effort, expense, and tailoring into the outfits they wear. I don't know who that is on the left, but I can tell you on the right, that is Justin Timberlake and Britney Spears many years ago wearing sort of full denim blue jeans on pants and jackets and tops and bottoms for an occasion that probably required something a little bit more formal. So all joking aside, what's the worry? Why do we care? Well, any of these highly customized approaches to antitrust often takes a very, very long time and costs a great deal of time and money and personnel, whether it's done by the agencies, whether it's done by the legislature or an executive branch or by a court. These things take a long time, and they produce varying degrees of attractiveness, both in the fashion world and in the law world. And sometimes the tailor, the court, the agency, the legislature get so caught up in admiring the craft that they lose sight of the purpose. And there is an effect on all this on the rule of law. Uniformity does have its virtues. It is, generally speaking, uniform rules are easier to understand. Generally speaking, they are easier to apply. They are easy to counsel. Your clients may not like the answer, but sometimes no. I mean, of course, they'd rather have the answer be yes, but sometimes no is more valuable to them than maybe for purposes of business planning. And so both Professor Furst and I see a trend that is not all bad, but has to be carefully parsed out as to whether this growing, complex and highly specialized rules of narrow rules applying to very limited circumstances is the right way to go. So if that's the worry, what to do? We hope this paper contributes to seeing the problem clearly in a, hopefully mildly fun but useful fashion. And more importantly, after we talk about with you and your questions, what is it that you really want to do? What is it that agencies and courts and private litigants should do in this situation? Well, for any enforcer, there's a cost-benefit analysis that has to be done before you walk away from clearly established simple rules or simple standards and embark on this path of customized, tailored rules. You have to both make sure that you have the expertise to do it right so that it's beautiful, and more importantly, that it does the job that it's intended for. In a world where this approach is becoming more and more prevalent, both Professor Furst and I are concerned that this tends to leave smaller and newer jurisdictions behind. I speak from time to time with different government agencies, and some of them obviously, like the FTC and the Justice Department, have hundreds of lawyers doing competition work. But even then, resources are not infinite, and there are many agencies around the world where you're talking about a couple dozen professionals, and to embark on a case or a development of a new rule or regulation that's highly specific will be very, very resource intensive and take cases away, time and resources away from cases that need to be brought, either mergers that have to be decided one way or another, and very important basic matters like cartels and other situations that are extraordinarily important in virtually every jurisdiction. And in judging when to embark on the path of customization and when to stick with the well-known basic rules of general applicability, it raises in our mind genuine issues of equity and inclusion at very many levels. And so we would suggest, like in fashion, good rules of general applicability are like jeans and t-shirts that you need in your closet for the everyday stuff that just comes up over and over and over again. And bespoke antitrust is best for special occasions, but special occasions of a particular kind that are important enough and recurring enough that it's worth the time and effort. And in the fashion world for guys, this is why many of us eventually buy like a tuxedo versus continuing to rent it, as long as there are enough special occasions that come up enough of the time that it's worth the cost benefit to finally buy the tuxedo rather than having to rent or borrow it or wear a gray suit to a fancier occasion. And so, for antitrust purposes, what are some of those fancier recurring special occasions where in our minds, we don't particularly talk about this as much as in the paper, which is more descriptive. So, for example, the topic of this conference in terms of competition and digital platforms, obviously digital platforms are extraordinarily important, extraordinarily complex, and they do pose certain recurring issues that are worthy of customized, tailored approaches. And while I generally support vigorous enforcement of the law, just remember that you can you can take out a garment, you can tuck in a garment through careful tailoring. The United States Supreme Court did some tailoring in the area of Section 1 of the Sherman Act when it created special rules for two-sided platforms in the Amex litigation. I have some criticisms of that case, but that is a way that you can take a special recurring situation and modify an existing rule to deal with that. And I would point to things like the Digital Markets Act in the EU and in other countries that are contemplating things of that sort. And again, rules more expansive in nature, but again, not just taking the basic ground rules of 101 and 102 or the US equivalents in the Sherman Act, and really creating some special gatekeeper provisions that have some do's and don'ts, because these are super important things. Now, it doesn't happen just in the area of high tech. For some of you may know that the FTC in the past year has explored competition rulemaking under its powers under the Federal Trade Commission Act. That's a topic of some controversy, but the first proposed competition rule in decades is a rule that would ban non-compete clauses in employment contracts. And the facts that helped influence why the FTC chose to propose this rule that has many steps to go through before it's finalized has to do with this is a recurring problem. The statistics are something like 20% of the working population in the United States, or something like 30 million people have a non-compete in their employment contract. Is it a matter, so it's obviously recurring, is it a matter of importance? Sure, it involves billions of dollars. It involves particularly lower wage workers being subject to rather draconian restrictions on their ability to move from job to job in the fast food or franchise industries. Does it need bespoke? Possibly. It's very, very hard to think of how you can attack this problem nationwide through case-by-case litigation, especially under the differing current laws of all 50 states that also have some rules in this area. So again, whether you like this rule or not, I would suggest that this is the kind of thing where you want a little bespoke antitrust. You want to deviate from just a general common law or Section 1 rule of reason approach and have some bright line rules so that employers and employees know their duties and their rights and their responsibilities. There's some exceptions in the rule, and that's all fine too. But again, I just suggest that that's an example of kind of a bespoke antitrust solution for a recurring special occasion of significance. As many of you know, the agencies in the US are also rewriting the merger guidelines as we speak, and nobody knows when these are going to be released. We're assuming it'll be sometime in the next few months in draft form. And again, you can imagine, regardless of how they change the existing 2010 horizontal merger guidelines, these will be highly bespoke guidelines that provide a lot more information, but a lot more customization than that basic Section 7 barring of acquisitions, which may tend to substantially lessen competition. So with that in mind, as long as the organizers of the conference allow us a few minutes, I'm happy to answer any questions, get your comments, and I would leave you with the following sort of just challenge to all of you, is just to think about in Hungary and any other jurisdiction that you work with and interact with, how many of the rules are bespoke in nature, how many of them are justified given the cost and the benefits versus having rules of general applicability. And like anybody's closet, it's mix and match. You're going to have some t-shirts you're going to have some fancy ones. And the question is, do you know when to bring out the one versus the other? And so with that in mind, I thank you for your time and attention. And I turn it back to the moderators to see how they want to do questions or comments, if time permits.
Thank you very much for this excellent presentation and talk. I turn to the audience whether there are any questions. Yes, please.
Well, thank you, Professor. I don't know where to look, where the camera is. I think there. Okay. Well, thank you, Professor. It was an excellent presentation, and I've read your paper. And one thing that I wonder is whether you could address the question that within bespoke rules, do we need to look for some uniformity? And what I mean is that the vans that we take our fancy clothes, are they similar in any nature, or do we have to look for any sort of similarity? Thank you.
Well, if I understand the question, the rules that come out are individualized, but oftentimes obviously have some things in common. And I didn't specifically get into this in the paper. This doesn't apply to just rules. It also applies to standards. But you could have a rule that says you can't drive more than 50 miles an hour on a particular street. You can have another rule that says you can only drive 30 miles an hour on the street because one's near a school and the other is a highway, and those are just different rules. You can also have standards that say you have to drive safely without a specific kilometers or miles per gallon per hour. But you can also have different standards, because driving safely for a professional truck driver is different than driving safely for a very elderly person who has vision and other health problems. So, these are just analogies. In the legal world, there are cases that have to be decided. And in my view, the rule of law means that you need to decide like cases in a similar manner and decide different cases differently. But that doesn't mean that everybody gets to get up and say, I'm special and I need a special rule for me. And I can tell you in the United States, this came up in the earliest history of the Sherman Act, where defendants in price fixing cases in industries that had been subject to cartels for years, but then suddenly had the Sherman Act, they tried to argue that they were special in 3 different ways. And these were almost always rejected by the courts. One way that they argued special was they argued that their industry was special, that the rules of competition were just a terrible idea for them. And so like the railroads, which had high fixed costs and low variable costs. And they more or less said, if we don't fix prices, we'll go out of business. We'll never earn back the amount of money it took to build the railroads. And the court just said, you might be right factually, but the law is uniform and applies to you until such time as Congress passes an exemption or some other set of laws that apply to you. So, thank you. We believe you, but that's a confession, not a defense. Second, the defendants argued, well, fine, okay, the law applies to us, but our arrangement doesn't unreasonably restrict competition because we've set a reasonable price. And again, the court quickly just said, that's not what we mean. If you unreasonably harm competition, that's the end of the story. We don't get into whether you fixed a good price, a bad price, a high price, a low price. And then finally, some more sophisticated defendants argued, well, we understand that this could harm competition, but we did it for a socially valuable reason. The best example I can give is the National Society of Professional Engineers had some rules that restricted price competition and bidding to construct public work projects like highways and bridges and towers and that sort of thing. And they said they did that to prevent people from underbidding and using substandard construction materials and labors and endangering, the public, because obviously you don't want a bridge that falls down. The Supreme Court said, you're not bad people, you just don't understand the antitrust laws, and we have these uniform bans on things that unreasonably restrict competition, regardless of why you did it. We don't look at the why, we look at the what, again, unless Congress tells us otherwise. And so there's just a tension and a balance between, that's been going on for years. And I'll let Professor Furst speak for himself. In my view, we've tilted, particularly in the US, in my experience, a little bit too far toward the bespoke, but there's still a place. It's just, it takes a lot of time and attention and expertise to figure out how different a particular industry or company or practice is. And sometimes it's worth it. And, in general, if it's just highly similar to other things that have always been lawful or unlawful, I'm happy to go with the jeans and t-shirt and just say a nice simple rule is fairer, easier to apply, and makes more sense, in a world where we have 130, 40 some enforcers, all of whom have different budgets and priorities and needs for their country. I would hate to have the trend to bespoke take away from just hardcore cartel enforcement against the necessities of life that really harm people in the real world, particularly those who have less resources.
Thank you. One short question. So this is the ideal law, like tailor-made to the behavior, if I understand this correctly. But how does this relate to the sanctions, or remedies, can I go to jail for a tailor-made based on a tailor-made antitrust?
Yeah, that's a great question. I think that's one of the great success stories of criminal enforcement in the United States, which is, by and large, almost entirely, the Justice Department will not bring a criminal case against something. I'm sorry, let me back up. Will only bring a criminal case against something that is per se unlawful. They will almost always bring civil cases against anything that's under the rule of reason, or that would be very difficult to prove to a jury in our system beyond a reasonable doubt. So we limit, taking away someone's liberty, and also criminal is the only fines that we have. There's no government fines in civil cases in the US. So putting someone in jail and or fining them or their company a lot of money, is a very, very serious sanction. And I'm comfortable that those are limited to categories of behavior that are covered by general rules, and we have a long history and a lot of protections for the defendant, so that we don't make the mistake of putting an innocent person in jail as best we can in this area. And so things that are more customized, things that are more bespoke, things that are more highly tailored, are almost always subject to some kind of rule of reason or case-specific analysis in the US. They're challenged as civil conduct when the government believes there's a problem, which means there's no fines, no imprisonment, and whether it's the Department of Justice or the FTC or State Attorney General, the remedy is primarily stop this, stop the conduct, some kind of injunction or cease and desist order. Private parties can sue for damages if they can show that they've been harmed because of that. But even in the private sector, most of the cases are per se cases where someone has engaged in price fixing, oftentimes where they've been punished or in litigation with the government. Those cases are easier. They're not easy by themselves, but imagine having to prove from the start all the elements of a rule of reason monopolization case where the government has taken no action. That's a very difficult task. So again, if I'm understanding your question, at least in our system, the highest sanctions, whether they be monetary or imprisonment, are reserved for the conduct that typically is covered by very plain, very straightforward, rules of general applicability, the per se rules, almost always.
Any other questions? If not, then my only task is to thank you again, Professor, for sharing your expertise and insights regarding this tailor-made antitrust approach. Thank you very much for being with us from Chicago right now. And my only
thanks so much.
Remaining task is just to conclude very shortly this first day of the conference, which I think we all can agree was a highly interesting and fruitful day regarding the digital transformation and the possible way of regulating the challenges that we are facing with. Also, we had very living debates after each panels, which also a great added value of this conference. And I invite you, either being present here or following us online, to join us for tomorrow as well. Thank you very much again in the name of the organizers, and see you tomorrow.